record on the clear issue that you dispatched us to go try to figure out before the jury was brought in, but otherwise we are ready.
Right, the appearances are as before. And what's up?
What's up, Judge, is no need to fret. Yesterday, after the whole issue with the report, I was able to go back to the Kenosha Police Department with forensic examiner Sean Morton. They had attempted to locate the report, and that attempt was unsuccessful. They could not find the report in the property. However, Examiner Morton was able to find the original hard drive download, which he said if he was going to generate a new report would take hours and hours and hours. I had informed him that I was really just concerned with the contents of that specific folder we were talking about, and we did go through the rest of the documents that were in that download directly from the computer hard drive. So I was able to review that. I have a copy of the documents that I requested. I was able to review that last night in its entirety. There were some videos that I was not able to review. However, I don't think that would preclude us from being able to move forward.
Well, what do you think of that?
I think we're ready to go.
Oh, well, that's all's well then as well, right? Let's proceed. And is the detective still on the stand?
Yeah.
All right. Ready for the jury?
Yes. Officer Morton was being copied in.
And
Would come down, please?
yeah.
Whenever I have problems with it. Or dumbass. And the problem is almost all my business. Good morning, everyone. Let's continue with the examination of Detective Morton, and go ahead. What's going on here? Oh. I beg your pardon?
You ready to go?
Oh, yeah. Fire away.
Thank you, Judge. So yesterday we seemed to have a little debacle about the report that was solved.
Yeah.
We were able to locate that back at the police department.
Correct.
In this case, you had completed a device extraction on Sadie Beacham's Samsung Galaxy S9.
Yeah, I did.
And you, though, were unable to do a SIM card extraction.
Have to review my report, but
I'd provide you a copy of that report, but it helped refresh your recollection.
yes. Yes, would indicate that there, yeah, well, probably was not a SIM card on the phone.
Well, there would have to be a SIM card in the phone in order for it to work, correct?
Not necessarily.
Maybe you want to flip to that second page and see if that helps refresh your recollection.
It still appears that there was no SIM card on the phone. It says SIM card check here. There might be a SIM number here. Oh, so it- oh, okay, correct.
Does that help refresh
So,
your recollection?
yeah, so there was a SIM card. It is, yeah, she needed the phone back, so I did not have time to do it, so it wasn't noted in the report.
Okay, and what's some data you can normally get off of a SIM card?
Nowadays, just the assigned phone number, the subscriber ID. SIM cards are normally just used to access LTE networks at this time.
Okay, and then you also noted in your report from the extraction on Miss Beacham's cell phone that the GPS location had been turned off, correct?
Yes,
And that the phone was encrypted.
yes.
Can you explain to the jury what it means when a phone is encrypted?
So an encrypted phone is when it's locked or not unlocked, so you can access it. All the data on there is encrypted, so if we were to just dump the memory chip from the phone, we really wouldn't be able to analyze it because it's encrypted. So you would need the PIN or the password to decrypt it in order to be able to view the files.
So even, and when you say you're going to dump the download, you have a lot of different software applications that you could use in an attempt to withdraw information or download information from a cell phone, right?
Yes,
And so you're saying that without the passcode, you would not be able to get any information off of Miss Beacham's cell phone.
I don't recall the specific model, but there are ways around encryption.
What are some of those ways?
Using bootloader programs, so like our Celebrate UFED unit, as a way to bypass that encryption or the passcode. We would restart the phone, and prior to the operating system loading, it would inject what's called a bootloader, which would allow access to the data on the phone without actually entering the PIN into the phone.
But that's something that you would still need to have the physical phone for, right?
Yes.
You couldn't do that from a remote location.
No.
When you do phone extractions, if spyware or anything had been uploaded onto a phone, is that something you would be able to see in the data of a phone?
If we're looking for it.
Okay. And in this case, there was no note of any sort of spyware or things of that nature on Miss Beacham's phone that you saw.
I did not run the malware program against it, so I was not looking for any spyware.
Why didn't you run a malware program to look for spyware in Miss Beacham's phone?
It's not a normal course of a case like this.
If someone, though, if you had information that that person claims that they believe someone hacked into their phone, you would want to do a malware search, correct?
Yes, but I was not told that any hacking attempts.
Okay. You also completed a device extraction on Motorola Play that was attributable to Mr. Anderson, correct?
Again, I have to read my reports, but that does sound familiar.
Are you referring to the Moto G6? Oh, different.
There's a play.
Okay.
I'm going to show you, well, strike that, the Motorola Play. Do you remember doing an extraction on that?
I do remember what Motorola is. I don't recall the
Okay.
exact model or who it belonged to.
You don't remember that?
I'd have to read my report.
Okay.
So yes, I did examine a Motorola Play belonging to Zachariah Anderson.
Okay, and that phone, you had noted that there did not appear that there was no record that there had been a factory reset of that phone, correct? You need to refresh a recollection on that. It's page 2.
Yes.
It's
So
the,
I actually did indicate it was factory reset. The last sentence on page 2.
do you know when?
No, I did not know the date or time. It was either not recorded or I was not able to find activity to indicate when.
But there were still some items from May and April, correct?
Yes, it looks like there was a picture taken in May. some emails found from April.
Okay, and then, that device was also, strike that. You also, back to the Motorola G6, you did a, did Detective Valerie also do extractions, to your knowledge?
I can't recall if she was assisting me during this time. Yeah, but I don't recall if she did any extractions on this case. I know there were several devices that were examined.
Okay. You also did an extraction on a tracker device that was located at Mr. Anderson's home, correct?
Yes, I did.
Grab that picture. So you have two exhibits, Defense Exhibit 239, Defense Exhibit 240. Does this look familiar to you?
Yes, it does.
Okay. And that was 239. I'm going to show you Defense Exhibit 240 now. Is this the information for the GPS tracking device that you did the extraction on?
Again, I have to review my report, but if that's a picture of the box, then yes.
I got you.
A lot of numbers. Yes, it is.
Okay, and you noted that for this particular device to work, it would need a SIM card inserted into it, correct?
Yes,
And that it didn't appear that there was a SIM card, correct?
no, there was not.
And you also said that the SIM card would need to be registered at http gpsui.net, correct?
Yes,
And that once registered, the device can be accessed either online at the same site or via the Android or iOS app, correct?
correct.
So in your other extractions that you did, including the MSI laptop, you did not come across any evidence that this GPS device was registered to be used, correct?
Correct.
Judge, at this time, I'd like to move into evidence defense exhibit 239 and 240.
No problem. No objection.
I want to talk to you about the exhibit 31 that the state had, which was this picture for Rewire Security Nano Tracker, State's Exhibit 31. So there's certain images where you can determine if it was a screenshot, if it was organically taken, if it was a tool like a snipping tool on the computer, you can determine what kind of file a picture is, correct?
Yes.
So were you able to determine what this was?
Yes. This was a file created by the snippet tool.
Okay.
Windows.
So that would mean that it could be taken from anywhere that was seen on a computer,
On the screen.
on the screen. That this wasn't a photo that someone had taken themselves.
Correct.
But you didn't you didn't analyze a tracker like this, correct?
No.
Did you look into at all how this type of tracker works?
Not this.
Okay, so you wouldn't know if this would need to also be registered like the other one with an app. And you wouldn't know how the information then would go from the tracker to an individual.
Object, because he's already said, I don't know how it works. So to ask multiple questions about what he wouldn't know when he's already answered, he doesn't know how it works, is repetitive and irrelevant based on his first answer. I don't know how it works.
Well, I don't know how the computer works either, but some of the time I'm able to actually operate it. Overall.
You can answer.
So no.
But regardless that you don't know how it works, don't know how the information gets transmitted or how the information gets accessed, whether it be via an app or anything, you did not find anything on Mr. Anderson's devices that would indicate he was registered to receive information or registered that device, correct?
That device, no.
You also completed examinations on things like a PNY drive, a Seagate drive, correct? There was 2 PNY drives and a Seagate drive,
I believe so, yes.
but you did not find anything of value on those.
No, I didn't.
You had talked a little bit before about Cellbrite. Can you explain to the jury what that is?
Albright's a company that specializes in obtaining data from old devices like cell phones, tablets. They now expanded it to computers. So it's a digital forensics company, basically.
And you're aware that there were several Cellbrite downloads done in this case, correct?
Yes, there were.
And one of those was of Mr. Gutierrez's phone.
Yes.
And that one was actually sent out to Cellbrite, the company itself, to complete.
Yes, it was.
And then you received a copy of that report.
I received a copy of the extraction they obtained.
Okay. And can you explain to the jury like what an extraction is?
So it's kind of similar to the hard drive from the computer. So we're just extracting data from the memory chip on the phone. Then that eventually gets processed and programmed to be able to see what's on that memory card.
And so you, even though you didn't physically do the Cellbrite extraction for Mr. Gutierrez's phone, you have done how many Cellbrite extractions in your career?
Thousands.
And you've reviewed Cellbrite extractions. How many?
Thousands, yeah.
Thousands? Okay. So you know all the terminology, the things to look for, things of that nature.
Yes.
Okay. Okay, I'm going to show you what's been marked as Defense Exhibit 298. So this is a portion of Mr. Gutierrez's Cellbrite report. I apologize. This is like terribly terrible as it relates to quality. Can you see everything up there okay?
Yes,
Okay, does this look familiar to you, the layout?
it does.
So does this look like something from a Cellbrite download?
It'd be, yeah, or generated from this plan.
Okay, so this is just a page, so it doesn't have on the top what it is. But if you see in all the action, it said all the action says launch, correct? From what you could see, and I'm focused on the highlighted ones.
Go on, please.
I'm sorry.
Under additional.
No.
Is that what you're talking about?
Under action.
Oh, yeah. Oh, sorry. Oh, once highlighted. Yes, it does.
Can you explain to the jury what that means?
Particular with the SMS that was launched.
I'm sorry, the what?
SMS app, the short messaging system, the texting.
And what does that mean when something is launched? That the SMS system on the phone was launched?
Opened.
It was opened. Okay. Activated. And so could you tell the jury at what time the mobile messaging was accessed or activated on Mr. Gutierrez's device? The first highlighted, actually the bottom one. So this one first.
May 17, 2020.
At what time?
9:23 a.m.
AM or PM?
Oh, I'm sorry, PM.
Okay. And then the mobile app, the SMS messaging on his phone was also accessed again. It was launched at 9:24:23 p.m. on May 17th, 2020, correct?
Yeah.
I'm going to show you what's been marked as Defense Exhibit 296. I'm going to go up here first. So again, consistent with Cellbrite download data?
Yeah.
Okay, and this says device events. Can you explain what device events are to the jury?
They're powering events, or in this case, orientation events. What you're going.
Okay, so we're going to start in the bottom here. So this says that Mr. Gutierrez's cell phone was unlocked at 9:26:24 p.m. on May 17th, 2020, correct?
Correct.
And then there's some other things: display on, display off, display on, display off, display on. Not going to do wax on, wax off, but you get it.
Yeah.
This could just be, these displays on, these displays off, could just be when the iPhone's face is lighting up, correct?
Correct.
That doesn't mean that someone's physically doing something, correct?
Correct.
Okay. And then at 10:10 p.m. on May 17th, 2020, the phone has an orientation change, right?
Yes.
Which means handing the band of my cell phone, we can demonstrate to the jury what that means.
An orientation changes. Rotate the phone, landscape or portrait.
Okay. So it means a physical change of the phone.
Right.
Okay. And that happened at 10:44 p.m.
Yes.
And this is for Mr. Gutierrez's phone.
Yes.
Part of a Cellbrite download too is you can get location data, correct?
At time.
Places, sometimes the phone doesn't have location data turned on, right?
Right.
So if it isn't on, you're not going to have the data. If it is on, you will have the data. And that would give you device locations, correct?
Correct.
So where the device physically is.
Correct.
Where a cell phone, or in this case, where Mr. Gutierrez's phone physically was.
Yes. Okay.
I'm going to show you what's been marked as Defense Exhibit 297. Probably going to have to hand this to you, but first, in real small lettering. Does this look familiar to you?
Yeah.
Okay, and you'd agree that this is on the Cellbrite app itself, the Cellbrite reader, and that's a software program that's accessible on a desktop.
Correct.
Okay, and this is I'm going to hand you it so you can. I'm going to hand you a different copy. I'm handing him the same copy that I just so you can read it. So this is the device locations for Mr. Gutierrez's cell phone, correct? Just yeah. And this, if we look at the location data that's on the right-hand side of the document, I'm going to zoom in so you might be able to see it on the screen now, but you might still want to read it there. And so this says that Mr. Gutierrez's phone was at these specific positions on, this is for April 26th, 2020 at 9:29 p.m., correct?
Not necessarily.
Well, it's saying that this is the device locations, right?
So we celebrate reports locations. That's really complex. So you got to take everything into account. You can't just look at a date and time and a location and say the phone was there. For example, if you receive an email that contains an address in it, that's going to show up as a location to Celebrate. Doesn't mean the phone was ever there. It just means Celebrate will processing that, recognize the location, and put it in the locations category.
But in this case, it could be. You don't know.
I couldn't say.
Okay. But we do know that we do have this data, right?
Yes.
And this data says that the device location on 4/26/2020 at 9:29 p.m. was at 6813 Highland Road, Mequon, Wisconsin, correct? That's what the data says.
He's already characterized that as the data says that address is of note at that time. He did not say that the data says the phone is located there.
I'm saying this is, okay, so I'm simply saying what the report says, what the data says.
Well,
that this is device, it literally says device location. Now I'm going into what the location, what it says. I'm not asking him to speculate. I'm simply asking him that this is what this data says.
Well, the exhibit speaks for itself.
Okay, I just want to get in the address though, Judge. So,
Hey, imagine it speaks for itself.
okay. Still like him to read it. I don't think that's an impermissible question if I ask him to read the address. May I do so?
Well, it'll take less time for you to do that than it will to argue over it, so go ahead.
Thank you. So the address here that's listed is 6813 Highland Road, Mequon, Wisconsin, correct?
Correct.
Judge, I'd like to move into admittance defense exhibits 296, 297, 298.
Objection. Okay. If
I have no further questions, subject to recross.
Officer Morton, when you downloaded Ms. Beacham's cell phone, did you have the PIN? Or did you have to use this brute force attack, if you can recall?
We would just have the PIN first.
And that would be something she would have to provide to you because you wouldn't have a way of guessing that?
Oh, I guess.
You've done thousands of Celebrite downloads. Is it unusual to have GPS location data turned off on a phone?
More common now that people are aware of it. But in the last 5, 6, 7 years, we see it awful lot.
You see the
Turned
GPS,
off a lot, yeah.
and is that something you would specifically do in your phone for some specific reason,
I'm
or
going to object as far as relevance.
Your Honor, she opened the door to the fact that the GPS location.
Well, you had to finish your question. Go ahead. Is that something you typically do?
Is that something you would have to physically do to the phone to turn off the location data?
Yes,
And that's become more prevalent in the last several years?
in my experience, yes.
You were showed defense exhibit 296, specifically talking about orientation change and what that meant. Do you recall that?
Yes.
I'm going to put this back up. Now this says orientation changed to landscape at 10:10 p.m. on May 17th. Is that accurate?
Yes.
And the end time for that was 10:44:18. Is that accurate? Or
16 maybe, but
16, I apologize.
within 2 seconds, yes.
And end time, would that mean that something is now changed on the phone, so now it's the orientation hasn't been changed again because we don't see notice of that, just something's changed?
From this report, I would say something's changed.
And for instance, if a phone were to die, where it's in a position and then it simply runs out of battery, would we see something like this where it just ends, but it doesn't say anything about a different orientation?
It really would depend on the phone.
Do you notice one level up that the next time the next event on this device event says May 28th, 2020, that it's powered on? Is that accurate?
Yes.
So obviously in order for it to be powered on, would it have first had to have been powered off or
Correct.
battery died?
Yes.
And in your experience with phones, are there certain environmental conditions that can cause a battery to die quicker than simply running out?
Cold weather, coldness.
So if a phone were, say, found in a freezer, would the coldness of that freezer potentially cause the phone to die?
Yeah.
In terms of orientation changing, if you were to place a phone in a freezer or set it down in the freezer, would that then change potentially the orientation of that device from upright to landscape?
Potentially.
You were talking about this tracker picture that was located on the MSI laptop, states 31. And you indicated that this was captured via the snippet tool that we talked about yesterday.
Correct.
So in order for this to be captured, the person doing the capturing would have to see this image somewhere, this picture somewhere,
Yes, it'd be on the screen.
and then decide to capture that image,
Yes.
and then decide where to save that image on the laptop.
Correct.
So it wouldn't just automatically go somewhere. You'd have to make those sets of decisions to have this appear on the laptop like it did.
Yes.
My dad.
Okay. I'm going to refer to that individual as the defendant just for purposes of our discussion.
Sure.
So, okay. So when the defendant came and back to the car, what happened next?
I said, sure.
Okay.
And I went up with him and we went to the window. We walked around the balcony this time and we went up the stairs and we went to the window. And he looks at me and he says, before you do anything, go like this with your shirt to make sure that you don't get the breath marks on the window.
So I'd just like to have the record reflect that the witness, Your Honor, pulled their shirt up, blocking their ability to sort of breathe on objects, covering their nose and mouth.
Yes.
Okay. So then after you were advised of that by the defendant, what's the next thing that happened?
I saw I don't know how to refer to him.
Whatever you're comfortable.
Mr. Gutierrez, I guess.
Okay.
And I saw him sitting on the couch with my mother coming out of the bathroom. And I didn't think that it was going to be this hard. They were listening to music and laying there together.
And doing what together?
Just laying there on the couch.
Okay. So what room are you looking into from where your vantage point is?
The living room. There was a space in between the curtains.
Okay. And what window of your mom's place are you looking through to be able to see into the living room?
What do you mean by that?
Well, you're on the outside, correct?
Correct.
So which window? Is it a window that goes into the kitchen? Is it a window that looks directly in the living room? So what?
It's a window that looks directly into the living room.
Okay. And where is the defendant during that period of time?
Standing next to me.
Okay. And after you look in and see that, what is the next thing that happens?
We leave.
What? You leave?
We got back in the car and we were on our way out. And he didn't grab the voice recorder at first until he pulled out and pulled onto the road. And he stopped. He stopped right at the second entryway to our driveway and got out, took his sandals off, and went to the house.
So let me stop you. What footwear then was your?
He didn't have shoes on.
Okay, cool. Keep going.
He went into Mr. Gutierrez's car and took his registration and took a picture of his license plate.
Okay.
And
I'm sorry, you saw that from where you were in the car?
Yes, I personally saw that.
Then what happened?
And I saw him ring the doorbell, and then run back to the car and drive away.
Whose doorbell did he ring?
My mother's, but he also had grabbed the phone while he was somewhere in the time period from when he rang the doorbell, the phone was grabbed.
And which phone are you referring to now?
I'm the one that was placed in the air conditioner.
Okay. So after the defendant goes to Mr. Gutierrez's truck, takes a picture and takes an item out of the vehicle or takes registration, grabs back the phone, and he rings the doorbell, what does the defendant do next after he does those three things?
Comes back to the car with the phone.
All right. And then what happens?
Plays the phone.
Okay.
Of course, plays a recording on our way home.
Okay. And what, if anything, can you say about what you could hear on that phone recording?
Nothing.
Okay. So where do you guys go next?
Back to my dad's house.
Okay. When you get back, what happens next?
I walk in. He tells me to get some sleep. I then was sitting downstairs and thinking about what just happened, because I was a little like, did I really just see what I saw, what I just witnessed? And it was fine after that, I guess. And
So let me ask you, what did the defendant do next that you saw? So after you guys got home, what happened next, if anything?
He dropped me off and then he left again.
Okay. And you were not with him at that time?
No, I don't remember what time that was. We got back around 3 though.
Did he tell you what he was going to do next before he left?
No.
Okay. So now, if I understand you, by now it's 3 a.m. on your actual 12th birthday.
Yes.
Okay. Can you indicate what, if any, plan was ever suggested to you to try to get your mom in trouble?
Yes.
What plan was suggested?
The plan was for, now this might be a little confusing. The plan was for my dad to drive me and my little brothers to the house. And then.
To whose house?
My mom's house.
Okay.
And then he would put the boys to bed and he would drive all the way back to his house, call the cops from there and say, my daughter just called me, and I would have to call my mom, but not make it ring. So I had to call her, but the phone wouldn't be able to ring. It just had to ring on my phone to prove that that her phone was called. Only on my end though. So it would show that I had called her several times and she didn't answer. So that's the look.
Who was supposed to do that? Who was supposed to do that part of the plan? Okay. And is this on a day that you wouldn't have been at your mom's house?
No, this would have been a day where I would have been at my dad's house and my mom would be out.
Okay.
And the plan was basically to call the cops and say how my mom abandoned us.
All right.
And how I had to call my dad.
Okay. And who suggested this plan?
My dad.
And when he suggested this, what age were you?
10, 11.
And so I want to take you back to a time period before that April 24th birthday time period and ask, was there a time in the month of March of 2020 when your mom went on vacation without you?
Yes.
And during the first nights that your mom went on vacation, where were you going to stay? What was the plan on where you were staying?
I would stay at home at the house with my aunt.
Okay, and who was taking care of you?
My aunt.
And who's that?
Becky.
Becky? Okay. And do you know, is Becky actually related to you or just a close friend of your mom's?
No, she's like my mom's sister though. So she's not really my aunt, but.
But you call her that?
Yeah.
Okay. So she was staying overnight with you guys?
Yeah.
Okay. And during the time period that Becky was staying with you guys overnight in your mom's house, did something happen that caused you to be either disturbed or alarmed on a particular time?
Yes.
So if you can you tell me about what time of day? What's your best estimate on what time of day that happened?
It was pretty late at night. I mean, it was more like early morning. It was really, really, really early in the morning.
Okay. So can you give me an estimate on what time?
Maybe between 2, 3, and 4.
Okay.
Somewhere.
And if you know, was it a school night?
Yeah.
Okay. And were your 4-year-old brothers also at the residence?
Yes.
Okay. So what happened at some time between 2 and 4 in the morning at your residence that caused you to be disturbed? And I'm only asking about what you personally had happen.
Okay. I remember kind of waking up to footsteps up the stairs.
Okay.
And then I kind of drifted back off into a sleep. And then dad was standing at the side of my bed and he was like, get up for school, let's go. And I was like, what? And I was really confused. And then I was like, okay, because at that time, what am I going to do? I mean, my parents telling me to get ready at 4 o'clock in the morning. So I don't really know what the point of it was, but he had made breakfast.
So what time did you eat breakfast on this particular day in March of 2020?
I don't know. We had French toast and eggs, and the time wasn't very clear.
Was it before 4:30 in the morning?
Most definitely.
Okay, and you ate? Who else ate?
My 2 little brothers.
And how did they happen to get up and have breakfast at that time on a school day?
My dad came into our rooms and woke us all up.
Had you been expecting your dad in any way, shape, or form to arrive?
No.
Okay, so let me ask you, if we get to a point where you on a Sunday go to the family tree farm, do you remember that?
A little, yeah.
Okay, and what vehicle got you to the family tree farm?
The van.
And is this a regular vehicle you have that you know of, that you are familiar with?
Yeah.
So who usually operates that van?
The defendant.
Okay, and if you saw a picture of that van, you'd recognize it, you believe? Yeah.
Yes.
Okay. So I'm going to show you a picture up on the screen in just a second.
So it states Exhibit 1.
And this is States Exhibit 1, number 254. And I'm just asking if you think you recognize this vehicle.
Yes.
Okay, whose vehicle is that?
The defendant's.
Is that the van you were mentioning?
Yes.
And so who went in that van to the tree farm, if you remember? Again, I'm talking about on a Sunday, May 17th.
Me, the defendant, and my
I'm
2
going
brothers.
to object that you just said Sunday, May 17th.
I apologize. So on that weekend, okay, apologize. On that weekend,
There's an objection.
yeah, I'm altering the question. So I'm,
Well, what weekend are you talking about?
what? I was about to say,
Specify the weekend.
yep, on the weekend of May 16th and May 17th, okay, of 2020, you went to the tree farm, correct?
Correct.
And you went in that van.
Correct.
Okay. Who drove it?
The defendant.
And if you recall, what were the state of the seats in the van?
There were 2 middle seats, 3 back seats, and 2 front seats.
Okay. And do you remember which seats were in on this particular weekend?
Yeah.
You remember? So if you remember, which ones?
Well, not the middle ones, just the back ones and the front ones.
Okay. And who on the trip to the tree farm, where did you come from? So what residence did you come from to drive to the tree farm?
My dad's house.
Okay. And so where were the twins in that van?
The back seats.
And where were you?
In the front seat.
Okay. And do you remember any items that your father, that the defendant also put in the van?
Just a chainsaw.
Okay. And so was that in the van as well?
When?
When you went there?
Yes.
Okay. So, about, if you know, approximately how long were you at the tree farm? About.
4 hours.
Okay. And during the time you were there, did you, what, if anything, did the defendant borrow from anybody else?
I'm going to object as far as foundation. He just asked that, what did Mr. Anderson borrow?
What, if anything, he said, did Mr. Anderson borrow?
Correct. And so I'm objecting as far as foundation for that question. Hasn't been established what she was doing at the tree farm, who she was with, what she had the opportunity to observe. That's just the objection.
Oral.
So what, if anything, did the defendant borrow while at the tree farm that you were present for?
Just my grandfather's boots.
Okay. Are those work boots?
Yes.
Okay. And ultimately, where were those work boots when you guys left the tree farm?
I don't remember.
Okay. Did you tell law enforcement at some point that the boots were brought home with you guys in the van?
Most definitely.
Okay. So when you came home from the tree farm, what transportation did you use to get home?
The van.
And who drove?
My dad.
And was there any difference in who was seated where?
No.
So on that weekend of the 16th and 17th, did you have an opportunity to see how the rug was in the back of this van?
Yes.
Carpeting. Okay. So I'm going to show you a picture. And this is picture what?
States Exhibit 1-260.
So this is Exhibit 1-260. Do you notice that there's something cut out in the van in this picture?
Yes.
And was that area cut out when you and your little brothers went to the tree farm on the weekend of May 16th and May 17th of 2020?
No.
Can I show a picture with the stains? I'm going to show you another picture. When you were in this van on the weekend of May 16th and May 17th, what, if any, smell of bleach did you smell in that van?
No, and those stains were not there either.
So you see some stains on this picture, and again, this is Exhibit.
States Exhibit 1-257.
So those stains were not on the van.
No.
When did you last see the van where you looked inside it? Was it on the Saturday or the Sunday, if you remember?
No.
Okay. Just on that weekend?
Yeah.
Okay. And the last time you saw that van, in terms of the interior of the van, was when you came back from the tree farm? Or did you guys go elsewhere after that, if you remember?
No, we just stayed at the house and waited for Mom to pick us up.
Now, so on that Sunday, did the defendant drop you off at your mom's, or did your mom come and pick you up, if you know?
No, my mom came and picked me up.
And when your mom came and picked you up, do you recall what the defendant was wearing in terms of outerwear? Do you remember that?
Yes.
So we're going to show you State's Exhibit 42. So first, can you first tell us what you remember that he was wearing? Please, before you show it.
He was wearing a white tee with jeans, sandals, his usual, and a blue flannel.
Okay. So I'm now going to show you what's been marked as, one more time, State's Exhibit. Can you make that a little smaller? Thank you. Do you recognize what that's a picture of in the context of this case?
Yes.
What is that?
My dad.
Okay. And in terms of what the person is wearing, what the defendant's wearing, is that familiar to you based on what you've said today?
Oh, yeah.
What is that?
His blue flannel jacket.
Okay. Is that the same blue flannel that you're saying that he was
I
wearing?
saw on that day, yes.
Okay.
And I think
During this time period, when you were at the tree farm, in that time period of mid-May of 2020, what, if anything, can you say about whether your father was discussing a boyfriend of your mom's?
Yes.
Okay, so when you saw the defendant, how often during that time period? So let's start from like March of 2020 until this tree farm visit. How often, when you saw him, would he discuss with you your mom's boyfriend, or this person that might be your mom's boyfriend? How often?
Pretty frequently.
And what did he call this new person in your mom's life? Did he have names that he called him or not?
Yes, there were, but it would be disrespectful for me to say them in this courtroom in front of his mother.
So I'm asking that you say the names. So what if any names do you recall specifically? Thank you for telling us that. But
Beaner and Booger.
okay. And why was he? Why did he say, if he did he explain to you why he was calling Rosario Gutierrez, or this person, the new boyfriend of your mom's, Booger?
Well, of course, the first one is because of
I'm asking about Booger.
Well, when he looked through the window at my mom's house on the morning of my birthday, he saw him apparently pick his nose and wipe it on my mother's couch. And so it was a thing for a while that we wouldn't sit on the couch. It was really just, it was a very odd situation, I guess. I don't know how to explain it.
And after that time, was how often was the name Booger? Did it come from from the defendant's mouth talking to you?
It was used in a joking manner if he was joking around about it, but other than that, it wasn't very used.
Okay. And did your what, if anything else, did you hear about about whether the defendant planned on?
I'm going to object to leading.
Well,
I have to get her there somehow, Judge. I'm not. Again, I'm not.
Is not among the permitted methods ordinarily, except in exceptional circumstances. He hadn't finished his question, so I don't know where he's going. So you can finish your question.
What, if anything else, did the defendant say to you about additional?
As we've discussed before, some lawyers have, either by practice or by education, been given the idea that if they put in the words, if anything, it's not a leading question, and that's not universally true. So although I am not prepared yet to denounce your question as leading, why don't you try to rephrase it anyway?
Well, what if I take out if anything? I still don't think it's leading. What did the defendant tell you about other plans to follow or come across Rosalio?
That's leading.
No,
He's saying what would...
he's suggesting the existence
Correct.
of a conversation.
Correct.
My previous question allowed the option of that there was no conversation. This one asked what the contents of any conversation was.
It's asking for specific contents.
If I could finish. Somehow I have to be able to get her to the topic. It's not, it's not what did you say next? What did you say next? That narrative will not allow me to get her to a topic.
How about, do you recall any other conversations?
But the conversations with the defendant would be, they saw each other all the time. There'd be conversations about everything. You know what I mean? I'm trying to get us to a particular location.
Well, my understanding, Judge, was that this line of questioning had to deal with when she was at the tree farm with him.
No.
So it's...
No.
Well, then if it's overbroad, then
Give
overbroad.
it another try.
Do you know anything about anyone's plans to go to Rosalio's home?
It was an odd discussion.
And who were you having the odd discussion with?
My dad.
And so what was that discussion?
It was, he said something about showing him who the man was. And I didn't quite understand, but you kind of caught on to things that my dad was referring to or was implying.
And has anyone ever had any discussion with you about watching Rosario Gutierrez other than the time you looked in the window? Has anybody ever said to you, hey, I'm considering watching Rosario Gutierrez?
No.
Following him, those kind of things.
My dad said to me, he said, I may just watch him or follow him to his house one time just for the fun of it. Those were his exact words to me.
So you indicated that you saw your dad take something out of a truck and take a picture of a license plate back on the April 24th into 25th of 2020, correct?
Correct.
After that, did you see any items in possession of the defendant that were from that same incident?
That did not belong to him?
That did not belong to the defendant. It belonged to somebody else.
Yes.
Okay. And so what were the items that you then saw at a later date that did not belong to the defendant?
That night we got back to the house and it was more like the next day.
Okay.
And we took a look at what he was showing. I took a look at what he was showing me and it was a letter. I don't really understand what the letter was for, but it was a Dear John letter, and then it was also his registration for his car.
Yeah. So let me just show you a copy of 5 and ask you if this is the document that you recognize from Dad having those items. Only if that's something you do recognize.
Yes.
So what is 225 in terms of your recognizing?
What do you mean by that?
Is that the document you saw when you described some kind of, I think you said registration? Is that what
yes.
you meant? Okay. So is this appear to be the same document? A copy of the same document?
Looking at it, yeah.
Yeah. Okay. And was there some handwriting on the copy you saw, if you remember?
At one point there was, yes.
And who wrote on it?
My dad.
So now I'm going to show you
States Exhibit 1, number 323.
States Exhibit 1, number 223. I'm sorry, 323. My apologies. So does that look familiar in relation to that 225 I just showed you?
Yeah, that's his handwriting.
Okay. And whose handwriting is that?
The defendant's.
Is that handwriting you saw on the document when you saw it previously?
Yes.
And where were you location-wise when you saw these documents, this letter and this registration type document?
Standing on his right side.
Okay.
In his room, by his desk.
In his room at his home in Mequon?
Correct.
Okay. Now, on Sunday, May 17th, before you left, did you have occasion to see anybody in your family playing with Legos in a location in the house?
Yes.
And what location in the house was that?
It was close to like around my dad's house,
Okay. And where in what area of your dad's house?
the downstairs.
Okay. So in the downstairs of your dad's house, who was playing Legos?
My brother.
And when your brother was playing Legos, did you end up in the same area as he was playing Legos?
Yeah.
Okay. And what, if anything, did you observe that you then told law enforcement about later?
Well, a Lego had dropped through the floorboards, and so Magnum had asked if he could go down there and look for it. And I said, yeah, that should be okay. And then I went down and, like, with him, obviously, because it was, I'm not gonna lie, the basement was kind of creepy. So he asked me if I could go with him. I said, yeah. So I went down there. There was a roller chair, whatever, and it had tape and rope on it. And my brother had a flashlight. We went down there, whatever, got his Lego and went back upstairs. Didn't think anything of it.
So when you say roller chair, can you describe like where this kind of chair would be? And
Like a black armchair.
okay, like a desk chair kind of thing. Okay, and then other than the desk chair, were there other items down there that you then eventually wanted to tell or did decide to tell law enforcement about? What'd you see there?
What do you quite mean?
Well, in relation to the chair, were there other items that you saw that were in the vicinity of the chair?
The tape and rope?
Okay, so what kind of tape are we talking about?
Like duct tape, just normal duct tape?
All right, and what kind of rope? Really thin or thick, or what do you remember about the rope?
It's like heavy duty, thick rope.
Okay, and do you remember what condition they were in? Were they old, new? What do you remember about it?
They weren't old.
Okay.
It didn't seem like they were old.
All right, and where were they located in relation to this chair that sounds like it's in the basement?
Yeah.
Okay, so where were they in relation to the chair, the desk chair you mentioned?
On them, like
On
it was
them?
sitting on the seat.
Okay. And you last saw those supplies on May 17th on the Sunday before your mom picked you up?
Yes.
Judge, this would be a logical time for us to take a break.
All right, let's break at this point. Talk about the case. We'd watch and listen to any counter trial and 15 minutes. I think on the first occasion it was your victim witness person who came up here and grabbed about 5 or 6 of these hearing assist devices and was passing them out to people. They're there for people who need them, and after that they're on a first come first served basis because of the limited number that we have. And now today I noticed that when the last person over here arrived, another person, the person in the blue there, or green, I've got male color blindness, handed her one, and it was not the one she had been using. So she had been holding one, and that defeats the purpose of having them available for people as they need them. So that's got to stop. And also, ma'am, you're not allowed to chew gum in the court. It's not that I'm offended.
The next thing that we are planning on getting into, Judge, is this witness's knowledge of the extensive marijuana grow that was taking place at this residence. So I wanted to break so that, the court had an opportunity to talk about that. So I'm also, I understand that it is the defendant and the defendant's daughter, but there is I don't know if the court is watching the demeanor of the defendant, but there's an awful lot of facial expression happening, and it is clearly impacting a 14-year-old girl. And I'm not saying he's intimidating her. I'm simply making sure the court is aware of that, and I don't know if the court feels that there's anything untoward about that, or if it would be appropriate for the defendant to try to keep himself in check. Certainly, the court asked other witnesses previously to try to be as stolid as they possibly could. So
I have been watching both the defendant and the child's mother,
okay.
and others. Everybody, you're all being watched. And believe me, nothing that would be, in my opinion, an effort to influence the child in any way or make this more difficult will be tolerated, and it will be addressed rapidly. I have not seen anything either from the defendant or from mother that I thought was any kind of a problem.
Completely defer to the court. Just wanted to be sure the court was thinking about it.
No, it's a reasonable precaution.
Follow implications from witness to Mr. Anderson. I don't know if it was facial or just mouthing while they were just waiting for a question, but so maybe there could be some instruction about that too.
Well, I would expect that there'd be some mother and father are here and on adverse sides of a case, and the child got a very, very difficult experience he's going. I have not noticed anything either in the behavior of any of the spectators or nor did I notice. You made some reference to the child being affected. I had not myself detected that.
She is looking over and getting smiles from the defendant and smiling back. And
Okay, if I could, Judge, I've been observing her as Attorney Gravely's been asking questions. My client has not prompted any of that behavior. She has been looking over here and has been looking at him and smiling, and that's been unprompted. So I don't think the representations of the state are very fair right now.
I don't think he's suggested. Well, first off, let me start off by saying I can't see her face, and even if I turned on the TV, I wouldn't be able to see her face. At least I'm not supposed to be able to. So, so I don't know what's going on there. I have noticed that she has looked both in the direction of her mother and her father, which I think is quite normal. And I have looked at both father and mother at various times, and I haven't noticed anything improper. If I do, it'll be taken care of.
okay.
But I'm not going to. I would encourage both anybody, but particularly the parents, to resist any effort of recognition. On the other hand, I can understand why a parent wouldn't want to, when child is in a difficult experience, not going to give some kind of support. But it's a legitimate concern, Mr. Gravely, and it will continue to be scrutinized.
I certainly trust the stewardship of the court with that issue. So, okay, so
Plus, I think there are stills being taken. So will enlist the aid of I'm not going to tell them what to do, but of the Fourth Estate, if they see anything newsworthy, and snap a shot.
Oh, good.
Okay. All right.
okay, so I do need a short break, of course, but also then the issue would be the next area of inquiry I intend to go into is what this then 12-year-old daughter has in terms of knowledge of marijuana being manufactured, produced on a large scale at this location. It goes directly to her credibility as a reporter of information. She is many of the things she says are confirmed by the search warrant, and so and that's evidence already that has been brought out and is in evidence in this case. I don't intend to belabor it, but I do intend to talk about the things that she specifically brought up in the report, because I think when a jury when her truthfulness about any of this is challenged, then the jury has a full ability to determine, okay, based on what she said, what is it that could be verified by other means? And much of what she can be verified is that.
I'm not going to repeat the entire objection that the defense had previously made as far as Marquand Washington went, but the essence is the same.
No, it's not the same.
I'm saying that the essence of the objection,
Okay, fair enough.
not the situation, the same legal analysis that we had done previously, and that other acts evidence shouldn't be used to bolster a witness's credibility when the claims aren't to it's not to an element of an offense, it's just to the credibility. And this individual is just a witness. So that's what I meant, Judge, by that it's in essence the same, is that our legal argument would be the same.
Well, I'll tell you what, the situation with Mr. Washington was different in the sense that it was going to get into a couple of drug dealers bragging about their business performance, if believed, and it added, in my estimation, nothing to bolster anybody's credibility. On the other hand, there is evidence, as Mr. Grayley points out, about the defendant being involved in some sort of a marijuana growing or cultivation, and so there, I don't see it as causing any particular harm in the case. And I think some very brief examination in this area would be non-prejudicial and contextual. So, and it's, again, I don't even think it approaches the category of other crimes, wrongs, and aids. So
That's fine. And then just on that decision, Judge, again, just reiterating that I will be seeking cautionary instruction 274. And also will note that if the state at this point, the defense views that given the ruling and the state's assertion of what it's going to be bringing in has opened up the door for us to question other people, such as officers, on the items that were found in the home as it relates to marijuana. So they want to open that door, that's up to them. But we will then be going into it, given the court's ruling and the state's assertion.
I'll leave your remarks without comment. I was going to say something.
You were probably going to say that the attorneys really deserve a break of about 5 minutes.
All right, I can see we've reached a time of desperation, so go ahead.
What time, Judge, do you want us back?
Oh, let's aim for about 2 minutes after 11 accurate time.
What time?
2 minutes after that clock. There's some time freak.
At 10:53, yeah.
Yes.
It's
I have to go to the
let's say in
bathroom.
7 minutes.
Up through that visit you had at the tree farm. At your father's residence, what, if anything, do you know about drugs being produced there, made there somehow?
Quite a bit.
Okay. So what drugs do you remember being produced there in some fashion?
Marijuana.
Okay. Any others?
Not that was grown.
Okay. And as to marijuana, what do you know about what was happening at that residence? Meaning your dad's residence, the defendant.
He was growing it.
Where in the house was it being grown?
In between the kitchen and living room.
Okay. On the top level or on a bottom level, if you know?
No, main floor.
Okay. And what do you remember about the process that you saw? How was it being done?
There were a lot of plants there, and
Do you believe you know how many?
I do.
How many?
72.
Okay. And what do you remember about how they were being grown?
That my dad had a water system, and they were just in rows, and there was a place to dry them in the back, and it wasn't anything like a little small operation.
Okay. So describe the water system. What do you remember about that?
It was just like,
Judge, I'm going to object as far as relevance into going all the minute details of the operation.
Well, we are getting keep in mind, and it's been true throughout the trial, there are materials coming in that are not directly pertinent to the crimes charged in the information. And I've sustained objections to some of them. I also spoke with you earlier about some of the things that were let in that might ordinarily not have been let in, but for our evidentiary rules, I've permitted. This, well, I'll leave it at that. Keep in mind that the defendant is not charged with anything related to a drug offense. And also, it's being permitted for legitimate reasons in the case, which I'm not going to go into right now. But you're not to allow it to convince you that he is as a character trait or a bad character, and that he acted in conformity with that in respect to the offenses charged against him. It's what's called, it's admitted for limited purposes, limited admissibility, and please don't draw any inferences about his character as a result of that. Any question about that? Thank you. But
Can you briefly describe what you meant by a water system? What do you remember?
it was just, it required a lot of building in the process, and it took up a lot of the time. It just took a lot of time to build it and make everything work the way he wanted it to.
And what, if anything, can you say about observing the defendant tending the plants, busy tending the plants at times you were there?
Yeah.
Okay. And so what did you see him do that was tending the plants?
Just trimming them, cutting, just like normal, like, plant keeping, I guess. Like, if you were to grow marijuana, like, it would just be like a normal plant process of growing them and like trimming them and stuff.
And what, if anything, can you say about approximately when they were harvested, if you know?
No,
No.
I really don't know. That was something that he definitely did on his own time.
Okay. And what, if anything, do you know about whether what, if anything, did the defendant say about how much of it he had sold? What was your understanding of how much had been
The
sold?
last time I talked to my dad, well, not necessarily talked to him. It was probably a week before I actually last talked to him. He told me that he had gotten rid of it all, which then when they had went through the house, I found out was not true.
Okay, so when he said he got rid of it all, what did that mean?
Like he had sold everything that he had harvested from it.
Okay, so now I'm just going to show you a couple of quick pictures. So the first picture is which? No, not marijuana.
State's Exhibit 1.
Okay, so again, that's State's Exhibit 1, number 307. It's going to show up on the TV screen. I'm just going to ask you if you recognize this item from your father's home. Is that something familiar to you from your father's home?
Can I ask what that is?
Don't know. Okay. All right. Then I have no other question about that. So let me show you now what's been marked as
State's Exhibit 1.
State's Exhibit 1, 308. So that is an item in a container. Do you recognize that?
I know the mason jar is his, but I don't know what's inside of that jar.
Was there something kept in the refrigerator that you were told about?
I'm going to object. She's already said she doesn't know what it is.
Well,
This is actually a separate question.
yeah. Was there something?
I don't know what that is. In the fridge you were asking?
Yep.
I don't know what they were used for necessarily. There were mushrooms of some sort in the door side in a opening somewhere where you would keep your butter, right? In the fridge where you would put your sticks of butter. That's where it was, in his fridge.
And were the mushrooms stored in jars of this type?
I have no idea.
Okay. I'm saying when you saw them in the fridge.
No, they were in a bag.
Very good.
To me, that does not look like a mushroom.
Okay.
So,
What does a mushroom look like that you saw at your dad's house?
they
I
were.
object to relevance.
I assume we're at the very end of
Yep,
this.
we are. Very end.
Okay. You can try to answer the question if you like.
Okay. I don't know. They were like an off-white with some like brown of some sort, and they were just really thin. I remember them being very thin, like almost miniature slim mushrooms.
Hold on for just a moment. recall a time that something was found under your little brother's car seat.
Correct.
What was found?
I'm going to object. This is something that she has no personal knowledge of
I
and
do.
would have been told.
I do.
Well, when we're
About
talking
the
personal
finding.
knowledge in the courts, we're talking about something you've seen with your own senses or heard with your own ears.
He's told her about it. He's told her about it. The defendant has told her.
Well,
Yes.
it's-
Hold on. I'm asking her to be quiet. Tell
when
her
you
to be quiet.
say you know what was the source of your information,
Told me.
he told you. What's your objection?
So just how the question was phrased made it seem it wasn't, did the defendant say?
Okay.
So if that's what it's going to be, then that's fine.
Yeah.
Okay.
I'm sorry. The foundational question to
Fine.
get there. Yeah.
Fine.
So did you come at some point to know that a phone had been found under one of your little brother's car seats?
In fact, I knew about it. He had told me about this phone that he put underneath there. And in fact, he instructed me to watch where my mother was going on his desktop. And it tracked all the way to Mr. Gutierrez's house.
So at some point you saw that on a computer as well.
Correct.
Okay. I have no further questions.
Let's examine.
If I can just have a moment, there's pieces of physical discovery that I'm going to need for my cross-examination.
Go ahead.
Thank you.
National Park? 10 times? Or many times?
Good morning.
Good morning.
So I want to I'm going to be walking through a bunch of things that the state went through with you. But I also want to go through some other details. First thing is we'll start with the weekend you were at the tree farm. The state had said Sunday the 17th, changed it to the weekend, but you were there on Saturday, May 16th, 2020, right?
I probably was. I don't really remember the quite dates like that.
Okay.
Like referencely like that. But yes, it was somewhere around that time.
So because after you went to the tree farm, did you go back home and spend the night at your dad's?
You probably are right. It is Saturday.
Okay. Because you remembered that afterwards you went home and spent the night.
Correct.
And when you were at the tree farm, there were other people there, right? Who else was there?
I know one of my uncles was. I remember my grandpa being there. And that's really it.
Was your aunt there?
I don't remember.
And you said your grandfather and then one of your uncles, was that Solomon Anderson?
No.
Joshua Anderson?
Correct.
Okay. So you go to the tree farm, and what did you do that day?
Hung out at the tree farm. We were planting new seedlings and stuff in the field. I don't know, it was just a normal day at the farm. Like, there wasn't anything off.
And you said you and your brothers went?
Yeah.
And your dad. And so you guys get there, you're going to have a good day at the tree farm. When you get there, what do you do when you first get there?
Said hi to everybody.
So you got out of the car.
Yeah.
And then you went and said hi to everyone.
Yeah.
And then what did you do? After you said hi to everyone, what did you do next? You said you were planting saplings, things of that sort. So did you go out into the fields? That's basically what I'm trying to get at.
Sorry, before you said my aunt, correct?
Yeah, asked if your aunt was there.
I think that you would be referring to Zenith.
Correct.
Yes, she was there. Me, her, Josh, my dad, Grandpa,
The boys.
the boys. I think that was really who was it.
Yeah, so after you get out of the car, you say hi to everyone who's there. What do you do next at the tree farm that day?
I don't quite understand.
So,
okay. If you're asking what I was doing, I was hanging out with my little brothers.
okay, and were you hanging out in the barn? Were you hanging out in the fields? Where exactly were you hanging out
We
with
were
your brothers?
hanging out in the vehicle.
You were hanging out in the vehicle?
We had went back to the vehicle and then we ran around out in the field. The tree farm's pretty big. There's a lot of things for kids to do there. So, we just ran around, explored. I don't know.
Yeah, so you're out and about. You're not playing in the car.
No, not necessarily. No.
You're out on the whole tree farm, which it is big. Lots of things to do there.
Yeah.
And so then after you're playing, hanging out, do you all get dinner together? Or do you go back in the car and go back to your dad's house?
We probably stopped for food on the way back, I'm sure, because it was a long ride. But otherwise, we went back to the house and ate lunch there and then took a nap because it was part of our schedule.
And so when you were there for that day then, when you were at the tree farm, you were playing with your brothers. When you were playing with your brothers, was your dad around?
He was planting the seedlings, so no.
Okay.
He was out in Like, we were in 2 different fields. So
Because
no,
there's like kind of a front field and a back field,
the
right?
front field.
You were in the front field.
He was in the front field. I
Okay.
was not.
Okay, so you couldn't see him.
I could see him,
But
I
you-
just wasn't around him.
Okay. And he was with Josh and his dad?
Yeah, had gone back there like a couple of times just to see what they were doing, and stuff like that. But otherwise, I wasn't like back there all the time.
And so when they were conversing, if you weren't there, you wouldn't be able to hear them, though, about what they were talking about.
No.
Okay. So your testimony earlier was that when you were in the van, you were sitting in the front seat and the boys were sitting in the back seat of the van, and that there were no seats in the middle.
Correct.
And could you see that space in between perfectly without obstruction?
Yeah.
There was nothing. So in that,
There was obviously my own dad's junk in his own car, because that's pretty normal. But I mean, other than the normal stuff that was in the car already, no, there were no middle seats.
and there was nothing else on the carpet other than some trash and
Maybe some clothes or something. I don't know.
those
Just typical stuff.
typical man stuff in a van.
Yeah.
Yep. Okay. Counsel, would you be so kind to pull up the exhibit of the carpet, the back of the car with the carpet taken out that you had? What was that? Exhibit 1. I'm sorry.
260, I believe.
Okay, thank you. Pulling up what's been marked as State's Exhibit 260.
States Exhibit 1, number 260.
Thank you.
Carmen?
Okay, so you remember being asked about this photo earlier?
Yes.
And you had said that you did not observe the van like this on the 16th, right?
No, I did not.
So, I hate to make you get up. Maybe I'll just get up. But can I have your stick? Okay, so if the back seats were in, they would be locked in right here. Correct?
Yeah.
So if the seats are there, you're not necessarily going to be able to see directly underneath.
No, there was carpet underneath there.
You could see completely underneath.
I could see completely underneath the seat. That seat was not like that.
Okay, and you're saying that there was nothing in this area?
No.
Just open?
I mean, besides what my dad's stuff was in his car, no. There was nothing out of the ordinary.
So where was the chainsaw?
In the trunk.
Where in the trunk? The back seats are back there.
No. The trunk cuts off right behind the seats.
So there's enough space with the back seat.
The click, the back seat, stops right where you're
Right
pointing.
there. You're saying the chainsaw was right here.
Correct.
When did you see the chainsaw? I'm good with that exhibit. Thank you. Yeah.
When we had gone to the tree farm, I noticed that my uncle, grandpa, and dad were exchanging or fixing his, so that we had brought it there to fix the chainsaw. At the same time, my dad was also cutting down trees in his yard, so.
So you remember speaking with detectives on multiple occasions, right?
Which one?
I'm just saying it was not just one time that you spoke with detectives. There were multiple times.
Yeah.
The first time was when you and your mom went to the police department on May 19th, 2020. That was the first time, right? You guys went there together?
I'm not sure. I've met with so many different people and talked about this situation with so many different people. I probably couldn't even recall any of the times that you're about to ask me.
Okay. But the first time, so then do you remember it wasn't until the first time you met with law enforcement, you didn't tell them anything about a chainsaw, correct?
Correct. I didn't feel that it was very needed since it wasn't used for this case.
So you said, though, that one of the times you talked to detectives that while you were at the farm, your dad never took that chainsaw out of the van. Do you remember telling detectives that?
I don't remember saying that.
Is it possible you said that?
Not sure.
So what happened then? Maybe if you could explain now. Did he never take the chainsaw?
No, he definitely took the chainsaw.
Okay, so
He definitely brought it into the barn and they were fixing on it and doing chain stuff on it and seeing what was wrong with the chain. Oh yeah, I remember that like the back of my hand. He definitely took it out of the vehicle and brought it into the barn.
so then you wouldn't have said that he never took the
No, like I said, I did not say that.
You did not say that. That would be a lie if you said that.
Objection, to call something a lie would be to characterize.
Lie is one form of.
I will
inaccurate
rephrase.
Statement. Go ahead.
Thank you. That would be an untrue statement.
Same objection.
Well, inaccurate.
That would not.
Possibly.
Okay.
I'm not sure.
It's not what you saw.
I'm saying I'm not sure, but I do remember him bringing a chainsaw to the tree farm and him taking it out of the van and bringing it to the workshop.
And do you remember saying that your dad was wearing flip-flops when he got to the tree farm? And that he then changed into your grandfather's boots when he was there?
I do remember saying that, actually.
And your dad wore flip-flops
All the time.
All the time. Even in like weird weather where
I mean, snowing, sleet, heavy packed snow, he's wearing sandals. There's no question.
even when it makes literally
No sense. Yeah. Sandals.
yeah. Rain, snow, like you said, everything. And a lot of times too, he would wear these sandals and then change into different shoes when he was at the farm.
He always had other shoes. He just preferred to wear his flip-flops if he was running in and out of somewhere or just anything simple. My dad was very simple. So for him to wear flip-flops all the time, it was just easy for him.
Yeah. And his being simple also translated to his style, right?
I guess I'm going to object to questions about the defendant's style. It seems irrelevant.
The state talked about everything he was wearing. That's where I'm going with this.
Well, whether it was fashionable or not would be irrelevant.
It doesn't sound like it's terribly relevant.
Okay. Your dad had like the same clothes he would wear all the time, the same style. When I'm saying style, I don't mean something that's
He
stylish.
had different pairs of those clothes.
Exactly. He had this jeans and white t-shirt.
It was his go-to. I mean, waking up, sleeping, he was in jeans, maybe shorts sometimes, but mainly just jeans and a white tee.
Okay. And so when you saw him and not saying he's dirty, but he didn't have a washer and dryer at his house.
No.
Okay. And so he had on the 16th, when you were at the tree farm, he was wearing before he changed into the boots, the flip-flops, jeans, white t-shirt.
My dad washed his clothes. I mean,
yeah.
there were times where he washed his clothes. Like, he just had multiple pairs. And if you're asking me about his style, he wore the same thing every day. Like, literally every single day. There was nothing new about him. He doesn't change ever. Like, he's just him. I don't know.
Yeah. And so I want to go back, though, to the tree farm. He was wearing a white t-shirt, blue jeans, flip-flops.
And when on the 17th, when your mom picked you up, he was wearing blue jeans.
Thing.
The same
Yeah.
thing. Okay. Exhibit 300, Defense Exhibit 300. Star. Pair of blue jeans.
Why does that not seem like my dad's size and know those are not his?
These aren't his.
Nice. Well,
Good.
no, she's still looking. I don't want to touch him. Sorry.
Oh.
I just.
Levi's? I'm confused. He never wore Levi's. I could be wrong. I'm not sure.
Okay.
It's
Right.
also been a while, so I'm not really.
And I didn't think you'd memorize like each article.
On the way.
Oh,
You didn't memorize.
Ask another
You
question.
didn't memorize each article of your dad's clothing, right?
Not like that. I mean, once you kind of know him, you're just like, yeah, he wears jeans and a t-shirt. Like, I didn't really focus on brands like that.
Do these look similar to jeans your dad would wear?
The pockets do. The back does.
The back does.
For sure.
Next one's going to be Defense Exhibit 299.
Side. The print material you just received. I did not make any observation that was sent to the clerk and provide copies to you.
Again, Defense Exhibit 299.
is it a
White t-shirt.
But
Looks like a white t-shirt your dad would wear.
No, it does not actually.
Okay.
His
Why?
t-shirts I actually did pay attention to. His t-shirts were a different brand. So to me that does not look like his t-shirt.
But you said before you didn't know every single article.
I have his t-shirts. I have pairs of his t-shirts, which is why I know
But you
what his t-shirts are.
don't have every single one of them.
No.
Okay.
So you testified on direct that your dad had nicknames for Mr. Gutierrez, and one of them was Booger, and that he called them because what he saw by the window. But you also testified that you were right there by the window.
I was.
So were you able to see
After.
that too?
After.
So you weren't there the whole time?
The timing is mixed up. I was in the car when he had went. There were 2 times. He went the first time by himself, and the second time he went with me. Like up to the house. Same night, 2 different times.
Where were you in the vehicle that you could see everything that Mr. Anderson was doing? So on direct, right? You said right now you're saying there were 2 times. The first time was you pull in and in the bar, near the bar, right? That's
My father had told me what he saw.
Well,
Like
no,
up front, had told me what he saw in the car through the window. If that is your question. I was not standing next to that window when he was looking at Mr. Gutierrez the first time. I went up the second time. He had told me about this, but in the same way, I had seen him go around that corner.
So I want to break down kind of what you saw versus what you heard from someone else.
Okay.
So you pull in.
Mm-hmm.
You said that your dad had a video recording device.
Mm-hmm.
And then at some point he went behind to put another cell phone in the air conditioning unit.
Mm-hmm.
Right? That's behind the house.
Yeah.
But you're now saying
It's
you
on
were
the
in
side of the house.
You're now saying you were in the car this whole time. You're not out running around the house with your dad.
Objection. Hold on. She has explained that there's 2 different sections. She's out at sometimes and not at others.
I'm asking about the first time.
No, actually, you're not asking. You're saying what you understand the situation to have been. So you can ask what the truth of it is, and then the district attorney is reporting what he thought the testimony was. So why don't you rephrase your question?
I want to break it down a little bit further. You're saying there were 2 times your dad went up to the house that evening, right?
Correct.
The first time, you didn't get out of the vehicle.
No.
So I'm only talking about the first time.
Okay.
The first time you said you saw your dad with a recording device and that you also saw your dad put a cell phone into the air conditioning unit.
Correct.
During this time, you are still in the vehicle.
Yes.
It's dark outside.
But light enough where you can still see.
You said it was the middle of the night.
It is. That doesn't mean I have 20/20 vision, so I can see.
Oh, okay. So you then explain to me your mom's house from where you were parked. You were parked in the bar lot?
Yes.
And were you sitting in the front seat?
Yes.
And you were in the van?
No.
Or in the Audi?
Yes.
You're sitting in the front seat of the Audi. Which way are you facing?
We are backed up. So me sitting in the car, I am facing the tail of the car. I'm looking at the house. When Dad left the car, I was looking to see where he was going, what he was doing.
So you're facing the house. What wall of the house are you facing?
Have you seen a picture of the house?
Yeah.
Okay,
I am. So
I am on the bar side. I am near the back of the house. I am on, if you're looking at it from the field. I don't think you're listening.
So I'm just a little confused because you're saying you're on the bar side and the door with the window is on the complete opposite side of the house.
Correct. That does not mean that I did not see him turn that corner and when he came back to tell me what he had saw.
Okay, so again, I only want to know
Yeah, and
what...
I am. I'm telling you.
Just a moment. Please listen to the whole question and then answer, okay?
Mhm.
Go ahead.
Thank you, Judge. I only want to know what you saw, not what... We can get into what he told you later. This is only what you saw. So you couldn't see that door. You could not see that window from where you were parked.
Correct.
So then when he comes back, you said you get in the car and you kind of pull out, but you don't completely leave, right?
What?
So you said there were 2 times that he went to the house. And in your direct testimony, you said he got back in the car and then went to drive away, but then stopped and got out again. And that was when you came out of the vehicle. Right?
Again, that mischaracterizes the testimony. She indicated he came back, he got her. Then there's a third incident where he leaves the car where they partially leave. So when she is retrieved from the car.
How many times did you get out of the car?
I got out twice.
How many times did your dad get out of the car?
3 times. Twice. Because he did not get out of the car the second time when he came to get me. When we were still parked at the bar, he did not come and he came and got me. He didn't sit in the car, drive away.
So he didn't enter the car?
No, not fully. So he only got out twice and I only got out twice.
So the second time then, well, you got out 2 times?
Do I need to re-explain?
No. Please, you can answer question without a question.
I'm confused.
Okay, well, let's do this. No, let's not.
I'll just ask a different question.
Beautiful.
What was the second time, well, the first time you got out of the car then?
It was to go up to the house, to the window that you're talking about, where I can see through the crack of the shades. And that's when he told me to go like this with my shirt. So then the breath marks didn't get on the window.
And then you went back to the car?
And then we did. We both, at that point, had gone back to the car. And we were pulling away. And then we got to, it depends on which way you're going, but the second entry to our driveway, it was the bigger open end to our driveway. And he stops, gets out, and I get out and I'm like, what are you doing? And I see him taking pictures of his license, of Mr. Gutierrez's license plate, taking his registration. Somewhere in the time I didn't see him, but he turned the corner, got the phone, rang the doorbell, and came back to the car, and then we left.
So you didn't see him go to the air conditioning unit?
I did not see him go to the air conditioning unit, correct, but I did see him bring back the phone.
Did you see him go to the air conditioning unit that first time?
Yes.
So, did your mom ever talk to you about what she observed that evening?
I mean, she's my mother. There are things to be discussed about that I don't know how to answer your question.
Well, the question wasn't about the content. It was just, did your mother ever discuss the matter?
A bit.
With you?
Okay. And when did she have that conversation with you? Was it
A while
close?
ago.
It was close to that time.
Yeah.
And she told you that she thought it was your dad.
No. 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 I knew.
Well, I'm saying, what did she say? I'm not asking what
I already
you
knew
thought.
everything that my mom knew. She wasn't telling me anything that I didn't know already.
Okay. And do you remember telling her that you actually weren't there
I do remember telling her that. I did.
and that you just knew what had happened because of a video you watched and from what your dad told you?
Yes. In the beginning of all of this, I did not come out.
I didn't have a question.
I was
On May 19th, 2020, do you remember a time where your mom had left to go down to Kenosha to check on Mr. Gutierrez?
a bit.
Okay. And prior to that happening, your mom had had a conversation with you about how she was worried her friend was missing, right?
Objection. I think it calls for hearsay.
It's already been testified to, Judge.
I believe it's still a hearsay statement, even though it's been testified to.
It's an in-court statement.
We're going to break at this point, and please don't talk about the case. Read, watch, or listen to any account of the trial. And let's try to start again at 1 o'clock. Is that convenient? Okay, thanks. I didn't hear the last 4 words.
About how she was worried her friend was missing, right?
All right.
Judge, there was then an objection to hearsay. Hearsay has to be an out-of-court statement. Ms. Beacham did testify, and she testified that on May 18th, 2020, she had talked to her daughter about her friend, her concerns about her friend that was missing. Those were in-court statements.
Any response?
Yeah, I think that to ask this witness about that statement is still hearsay. I'm sorry, go ahead.
No, go ahead.
The out-of-court statement for this witness is an out-of-court statement. So the fact that it's been that it's in through a different party does not make it an in-court statement.
You're right. It does, however, affect the application of the rule. The objection's overruled.
All right. I'm not, okay. I don't think there's an exception, but I don't want to belabor it, Judge. I do want us to continue. So thank you for the ruling. I do have one other matter. So the court provided the parties an email. Mine, it appears the communication to you was at 11:31 a.m. I think.
Well, just so it's clear, it did not come directly to me. The clerk got it. Did you get it as a forward, or was that sent directly to you?
We did.
Okay. Okay.
So yeah, mine is headed your name. That's the only reason I indicated it was provided by you. But the message, as the court is aware, is that Court TV showed a clip where the defendant used his 2 fingers and placed them over his lips as his daughter was testifying to suggest to not say anything. We are aware now Court TV has played this clip multiple times. They have even slowed it down to be sure that their viewing audience was able to clearly see what happened, the gesture. So we have a copy of what they have played, but there are commentators who are speaking over it, so we cannot tell what the specific question is that it's in relation to, which I feel would be important to the court to know context. It certainly would be important to the state. We have asked Court TV, who have indicated that if the court orders Court TV to provide an original copy that does not have the commentator's voiceover, that they would provide that pursuant to the court ordering that in this courtroom today. And then all the parties would be able to see that clip and know specifically when the defendant makes the gesture, which clearly has occurred because we've seen video of it, what the context is. We know his daughter was testifying. We don't know what the question was or where she was in her answer. I am asking the court to briefly take a look at what we have. I'm asking the court for an order to Court TV so that we may finish our investigation of this. And if we have any additional information we think is relevant, we'll bring it to the court. The court will remember I expressed a concern earlier that I wanted the court to be as diligent as it felt appropriate to try to make sure that this minor child was not in a position where she was being influenced. And so I asked the court to also at this point impose an order that recognizes what has already been detected in the Court TV film.
Well, you're dating yourself because it's not filmed.
Did I say? Yeah. Oh,
Ah.
yes.
But anyway, is there a response?
I have watched. Thank you. I have watched the clip. Obviously, what we don't see in the clip is the other side because they're not filming Olivia. I will note that there were times, and that I did observe, that when the state was asking their question, while asking, Mr. Anderson's daughter would look over at him and would mouth something just mouth something. I can't say what it is. I can't say when that happened. I did not personally observe Mr. Anderson make these gestures. I've watched it now on here, but so I can't say if it was in response to that or not. But I will say that that was occurring, and it could be that that was a response to her mouthing while the state was asking a question. So that would be the only thing I have to add to that. I obviously can't speak any further.
So the minor is in the courtroom. I don't know if the court feels it's appropriate to have her here as we discuss this, but I should have brought that up earlier.
I just have noticed that.
Yeah. We do have the clip, and we would like at least to show the court what has been broadcast by Court TV now multiple times, so at least the court has that available for its in its knowledge.
Well, how difficult is it for Court TV? Okay, and I've been requested to order it, and to me, orders are last resorts. Can I request it?
We tried to go through those options, Judge, prior to coming up with you, and we felt like we heard them clearly.
Okay, well, it is something that may be of benefit to the trial. So, yes, under the circumstances, I will order that you produce that. Is that something that takes a certain amount of time or a foreseeable amount of time? Okay, great. If you would then, thank you.
And then, Judge, there was another issue that the defense was made aware of that Attorney Birdsall will speak on.
Yeah, Judge. So apparently, excuse me, this has been brought to our attention too. Obviously, we can't see everything that's going on, but that Ms. Beacham is apparently a certified in ASL, American Sign Language, and Olivia knows the language. And the observers that reported to us said that she was signing to her. I don't know what about. One thing that was mentioned was calm down. What else was signed to her? I don't know. And I have no idea if Court TV would have picked any of that up. They certainly wouldn't have picked it up on Olivia's end, but I don't know if they picked any up on Sadie's end. So maybe if we're looking at some of this footage, we could look at that too.
I'm sorry, I did not hear.
They only have that clip.
Oh, it's up there.
So I want to report to the court what I know about this, just in terms of reaction. So Sadie Beacham indicates she is not a certified American Sign Language interpreter or person of that sort. And most importantly, the minor child indicates she does not know that language. So she is not somebody who has that in her ability to understand.
I'll permit you to examine either or both if you want.
Outside using the presence of the jury?
Indeed.
Yeah. Ms. Beacham also denies that she did any of that. So.
All right, let's start one thing at a time. Can you run this?
Yes.
Is that a rerun or?
Yeah,
a rerun.
so because
There's only one incident.
well, that's the one that they were playing on court TV that we were made aware of. I don't know if there are others, but that's the one. And then I would play it with sound, but it's pundits talking about what's happening. It's not the.
Have they mentioned my tie?
They were more focused on what
The Marquette tie? No, all right.
They were focused on the efforts of the.
I understand. All right. Well, let's let that sit for the time being. If you wish, you may examine either Ms. Beacham or the child, and that's
Now?
up to you. Yes, outside the jurors' phrasing.
Am I going to have an opportunity to question the defendant?
Yeah, under oath. Yeah.
Well, the defendants we can actually see.
Okay.
I'm not in a position, so it may make a difference. I don't know. It's not on the merits of the case, so I wouldn't. Well, I'll tackle that if I need to.
Yeah, you might have to make a record of it, Judge.
So I don't have so far the source of this allegation. Counsels have represented to us that they have received this allegation. I have not seen this allegation, so I don't know.
When you say this allegation, you're talking about Ms. Beacham?
I'm right. I'm talking about the one that has been forwarded by the defense table, and I assume they are not. I understand them to not be direct witnesses. They are simply recounting something that has been reported to them.
Who are the informants?
Yeah.
So members of his family.
Okay.
Sitting
That they observed it themselves here in the courtroom?
Yes.
Okay.
And have evidently reported that Ms. Beacham is a certified interpreter of sign language, which we have told the court is not true, and also have evidently reported that that the minor in this case knows sign language, and she says she does not.
So let me.
So this does not come from the allegation we've described to you is not only on television, but it is apparently someone who has no connection to the case that we're aware of. The allegation the court has just heard has been family members who have been here all trial.
I haven't pressed for TV.
Right.
We were what I understood I was being told was that they don't have a video of the conduct which is being described on behalf of Ms. Beacham, but I didn't ask whether they have looked. So I don't know if if we're dealing with something which is unavailable or something which has not been searched for or found.
I suspect.
What can you tell me? Okay. Is that a satisfactory explanation?
Well, I've watched the live feed either at council table or if I'm out of the courtroom out, and I have seen them. Ms. Beacham's been on camera many, many times. So I'm just, the interesting thing, Judge, or the complicated thing is that, even if they were to do a search, you would have to have some specialized knowledge what to look for in terms of sign language, because I wouldn't know.
Well, but even the question of whether she had her hands anywhere in a position which could effectively communicate with a witness stand,
Yeah.
that would be something that would be searchable. But I interrupted you.
Well, I just don't know in terms of the coverage whether or not the lack of pointing the camera in that direction was just for this witness, because I know for a fact that I've seen, Ms. Beacham and the whole family there many, many times, those cutaways while the testimony is going on. So, and it might be a bit of a slog to look through some of that footage, but I can only report what was reported to me in terms of what was seen.
What was seen with the eye here in the courtroom,
Correct.
not what was seen on court TV.
Correct.
I assume that whoever's reporting this from the family is an American Sign Language competent person. Otherwise, why would someone make such a report?
Because they all know each other.
What?
Because they all know each other.
Sure, but I mean, this is a serious allegation for somebody.
No, I'm not trying to minimize the allegation at all. I'm trying to me, the awareness of whether American Sign Language was used could have come from the fact that these people all know each other and think that she is an interpreter or conversant with that language.
Right, but at least as the attorneys reported it to me, and please correct me if I'm wrong, I was told that the allegation, and it wasn't shared with me, it was a family member until now, but the allegation was that specifically this person reported that they had seen Sadie, the mother, who is a certified American Sign Language interpreter, interpreting or flashing signs to the minor on the stand, who also knows sign language. This is what was reported. What? And one example was calm down, but it was said in the plural when it was said to me. So for someone to take the leap and say, this was American Sign Language that was done over there, I assume it's a person with some competency in that before they would make such an allegation. But I don't know that. I'm just suggesting that is is it a person who has competency in this language so they know what these signs are?
Now, if I wouldn't join in your assumption, and I'm not saying it's wrong, I'm saying to me, if they know Ms. Beacham and have spent time with her over the years and are familiar with whether she speaks French or German or American Sign Language, that might affect what they would report to you, but I don't know. But we're getting way off track here.
Here's my concern, Judge, and I apologize for interrupting. we have reported to you something that has been nationally broadcast. The court's now seen the film. You've also heard reported a family member of the defendant, in what at least now seems to be highly speculative information, and our latest discussion from the parties is that we will be placing people under oath based on that highly speculative and potentially biased information. And the defendant, I mean, I don't know what the court's planning on doing next, but the defendant then we're left with no additional action taken at this time. So I feel like if one thinks about the scales in any fashion in this case, in those regards, that seems like an outcome that is that the court should consider.
And I never said I wouldn't consider it. I offered the opportunity for the defense to examine the witness and, the two witnesses about it. And I have not ruled out ordering Court TV to conduct the search that you're seeking.
I think the court already ordered it. Am I missing? Am I wrong?
No, yeah, you ordered.
You ordered it.
Speaking.
I ordered the search with respect
Right.
to the coordination of the testimony of, I haven't ordered Court TV anything with respect to the accusation about Ms. Beacham.
Right.
So if I misspoke, yeah. Okay. That was what when you were talking about having seen other instances where Beacham was pictured. I agree with you because I saw one or two myself, but I wondered whether they do things differently on different days, and I'm sure they do. And she's nodding yes, they do. So I'm going to accept her representation, and not have them search further because we've already given them one assignment. And as you heard me a moment ago, I was reticent about giving them an order anyway, but that was what they needed, so I gave it. But I will still permit you to examine the people involved about that, and you can examine these people who have made the accusation. As to whether you can examine the defendant about anything, that's a separate question. I'll have to take up if it arises.
As long as I'm also allowed to examine family members who have made such an allegation in this situation and find out their basis of knowledge, then I understand.
All right. So do you want to examine?
Yes.
Okay. Let me call the jury and tell them we're not just late at lunch.
Yep. You can take it down.
Amber just sent me.
Hello.
Forgive us. It's going to be a little bit longer. Hopefully not too much.
Okay.
Thank you.
Bye.
Longer. The fatalism of
Did
that.
she say longer?
Yeah. She did, kind of resignedly.
Yeah.
And who can blame them? All right, whom do you wish to examine? Ms. Beacham. All right, I'm going to ask the child to be escorted she can go in the library if she likes, or I don't know if there's anybody else back there.
Try to figure out back.
Would you come up, please, Ms. Beacham? All right, you're still under oath, ma'am. Please be seated. All right.
Ms. Beacham, I want to ask you about your employment, do you work as a care manager / social worker?
No, not anymore.
But you did.
I did.
For Community Care Incorporated at UW Milwaukee?
Well, those are two separate entities. One's a school and one is a agency that I work for. Yes.
So, Judge, I'm just going to ask, are family members currently texting defense counsel questions to ask?
No.
If that's
Well,
occurring
there's
right now?
a court rule that there's no cells to be taken out of pockets, so unless they're pretty efficient at texting,
Okay.
I would assume
I mean, I
not,
see
but
that
if they are,
Counsel's reviewing his phone. Apologize. All right.
Yep. So, I'm
sorry, can I ask one other thing? Your courts excluded this witness, so whoever is the individual who made this allegation, I'd ask they be excluded as well.
that makes sense.
okay. So
So that was the person just texting?
Yeah.
There are two leaving.
he wasn't texting me, so just relax.
Thanks.
So from July 2011 to December 2013, did you work at the Deaf and Hard of Hearing Mental Health organization as an employment specialist?
No.
It was called the Threshold Incorporated in West Bend.
I think you're looking at possibly a resume or something, and you are kind of mixing up the places. So
Okay. Did you attend UW Milwaukee?
I did.
Did you get a bachelor's of education?
Special education, yes.
And in deaf studies and interpreting certification?
I got a minor in deaf studies, and in order to be certified nationally, you need to take what's called a national interpreter certification, and I did not take that.
But you know American Sign Language.
I do.
Okay. And you're fluent in it.
Fairly fluent, yes.
Okay. And you taught your daughter as a young child and as she grew up how to do it, right?
Up until about Olivia was about 2. She knew animals, her numbers, and her letters.
So the answer is yes. You did teach her.
I did.
And in fact, on your LinkedIn page, you list languages where they have a category for languages, and one of them is ASL, American Sign Language, right?
Correct.
So when Mr. Gravely represented to the court that you said you didn't know it, that was just wrong.
I didn't represent that to the court. I said she wasn't a certified language. I said that the child involved here, the minor, does not know the language. I never said that.
There were some representations made which did not amount to what is being questioned now. But I'm not going to break the stride on this. But if necessary, we'll check what was said.
Okay. And so we've established you know it. You've taught your daughter.
I've taught her the basics, very basics.
All right. And you also volunteer at the Center for the Deaf and Hard of Hearing?
No.
So, and is that accurate that you've never volunteered for them?
No, that's not accurate. I used to volunteer for them when I was in school.
Okay. And how long did you volunteer for them?
While I was in school, so I don't know, a couple of years.
Okay. While you were volunteering for them, did that involve doing translations and interpretations for people?
So in my internship, I did have to do interpreting. Again, I can interpret, but I am not nationally, nor am I certified interpreter. But do I understand the language? Yes.
Okay. And so, obviously you've heard this discussion, so I'll ask you, while your daughter Olivia was on the stand, you had a sight line to her, right? You could see her clearly?
I was trying actually to not look at her, and I was keeping my eyes focused over at
That was not
the
the question
defense.
that was asked.
Oh, so no, I was not directly looking at her. Did I have a sight line? Is that what you asked?
That was my question.
Sure.
Okay.
Yes.
So you could see her, she could see you, right?
I can't speak for her if she could see me, but I could see her.
Okay. And so so just the real obvious question, were you signing her instructions about what to say or anything else?
No. My hands were below the pews.
Okay. Were you communicating with her in any other way without your hands, either facial expressions or whatever?
There was a moment where she got a little sassy up here, and my initial mom response was to go, shh, 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 shh. So if I did that, that would have been the only thing that I can recall I did.
Okay. And so to your recollection, your hands were below the level of the benches the whole time she was up here?
Correct.
Okay. Would you say that's true as far as you know for the other members of the family that were sitting around you?
I can say that the other members of the family are in direct line with me. And so if they saw my hands move, they would be the ones to see it.
Okay. Are there other members of the family that are ASL knowledgeable?
Not that I'm aware of.
No, no in-laws, no cousins, no anybody here?
On Zachariah's side?
No, on your side.
Not that I'm aware of.
Okay. So, can you tell us, and I realize this is going to be hard to make a record of, Judge, but can you demonstrate how it is that you would use ASL to sign the words calm down?
You'd probably just go calm down.
So you wouldn't use your hands?
Did you see my hands?
I can barely see you because of the
Exactly, because that's what I did over there. If I did anything, it's below. You can't sign calm down up here. That's impossible. And if I did, everybody would know what I was doing. You don't sign up here. You sign low.
Okay, so you sign low.
Like at your level, you don't sign up here. Those pews are pretty high.
Okay. So you did that then?
I'm saying they're low. So you're like, if you're like this, you can't see below those pews. So anything that she would be able to see from here to there, I can't see anybody's hands in any of those pews over there. So if I'm using sign language, if I'm using ASL, I have to use my hands.
Okay. When I just asked you to do it though,
I did it, right?
You're below.
Correct, because that's the sign.
All of the words calm down or like something like that. Do you do that simultaneously?
Sometimes.
Okay.
Occasionally.
Because that helps them because they can read lips too?
Some people can, yes.
Okay. And so did you do that in this case?
I don't remember. If I did, again, as a mom, if she's getting sassy, I might have said, shh, calm down.
So just for the record, you made kind of a side head mom scolding look, for lack of a better term. But
I think I made that to you. I honestly, you know.
And so, but you could have mouthed those words to her?
As a mom, possibly.
Okay.
Ms. Beacham,
Yes.
did you perform any sign language while your daughter was on the stand?
No.
None at all.
Other than possibly underneath the thing, but it was not to her. Like it was not, I was not specifically gesturing to her. It was just my mom reaction to just do this. So if I did this, that would have been the only thing I can possibly think of all day today.
And would your daughter understand any sign language to your knowledge?
Objection,
Well,
I
speculation.
don't know. I haven't heard the question.
this is the mom indicating what,
Just, you don't have to argue it.
other than what you've indicated you taught, which I believe are animals and numbers, and did you say letters?
Yes.
Other than that, do you have any reason to believe that your daughter would understand any other sign language?
Maybe a few. She's older now, but it wasn't something that I specifically taught her, like calm down.
Nothing else.
Redirect.
That was all, Judge. I think we're done.
Oh, we're done? Okay. Thank you, ma'am.
Yep.
Now, do you want the daughter or not?
Um, and talk to some of his family members.
And talk to family members, did you say?
So both the attorneys are gone, Judge. Remember, they left when you, yeah.
We don't have any more questions for Ms. Beacham, but we would like to call, what? Hold on. We would like to call two members of Mr. Anderson's family who were in the courtroom and witnessed conduct by both Ms. Beacham and other members of the family regarding signaling the witness. So first would be his brother, Solomon Anderson.
I'm just going to indicate so that we're aware. I'm going to ask to take a look at cell phones of witnesses because I believe there was texting of counsel before
They have a warrant.
But I'm just
Absolutely not.
making sure that we're clear. Yeah, so I'm going to ask to take a look at,
I'm not going to accept your prohibition when you're not their attorney.
That's fine, but he's making an assertion on the record. I'm allowed to respond to his assertion.
He's asking me if he can examine these people. He wants to look at their phones. I would probably let him as part of his examination of the witness. That would be, but and it's not, and you're not representing them. And oh, I'm sorry.
can I
Well,
ask,
here, no.
it appears that there are multiple additional witnesses. I intend to extensively cross-examine these family members, including asking them about materials, because I have, what I thought I saw was counsel receiving texts and reading it. And as I watched individuals leave, I saw them on their phones, and what it appeared to me was texting.
I did get texts from my office.
Yeah, no, I'm
or watching the live feed.
Sure. So what I'm suggesting, Judge, is that I am in no way going to assume that these people are honest brokers of information. I'm going to, and so because we have a jury waiting and we have a witness waiting.
Yes, and here's what I'm going to do.
Okay.
And you could try to talk me out of it if you want.
Sure.
And as you know, sometimes you can't. But my inclination right now is to everybody who has been named will not leave the courtroom with his phone unless I say so. That's number one. Will not make any alterations in the content of the phone's memory. And rather than probe deeper into this, I'm just going to let you examine these people who, on either side of this. You'll be allowed to present that video if you want, and whatever Court TV comes up with, or you could if you wanted to. And then with respect to Ms. Beacham, I'll allow evidence on that subject, all of it to be heard by the jury, because I think it's all perfectly relevant to the case and to their judgments on credibility. Anybody have any reason why that is not an appropriate resolution? So we don't spend any more time outside the jury's presence. Instead, let the jury decide.
Respectfully, Judge, before we agreed that we would do this outside of the presence of the jury, I think it's appropriate to continue
that.
that.
You agreed, but it isn't what I said.
I believe it was what the court had said, that we would have we would have a hearing on this issue with witnesses outside of the presence of the jury.
And we did.
So any further witnesses are going to be in front of the jury?
This jury has been here now. They were told 2 weeks. We're going on, I've lost track. Three. We're going to get to business. I think this is all perfectly relevant. If there's a suggestion that people have been trying to affect the testimony of a child who would be quite vulnerable, then the jury should have that information available, and they can make their own decisions.
recall, the only issue regarding Mr. Anderson's the clip from court TV, we can make representations.
But at what's not shown in that clip, it's out of context in the sense that as soon as he saw that Olivia was mouthing at him, and I didn't see that, but he was alerting us to that. So we can't, we can't become witnesses. We can't call him. So, that's as far as that clip goes, that's a problematic area.
Oh, you have no idea how problematic it is. So now we have lawyers on both sides who are alleged to be disqualified.
Yeah.
So my suggestion at this point, Judge, is to allow the minor child back on the stand. Let's finish her testimony. I'm concerned we might, at this point, that this young woman might be in a situation where she might have to come back. And so my priority right now is not to resolve the issue that we have before us right now. The court has a jury waiting. Let's at least finish this witness. Then the state has one remaining witness, and if the court wants us to talk more about this or litigate this, or the parties can have a discussion about this, sometimes we've been able to work things out previously. We maybe will be able to talk about it again. But at this point, let's prioritize the witness and the jury would be my request, and we'll get back to this at a point the parties are ready and that it's appropriate to do so.
Well, I agree with about 2/3 of what you said.
It's an excellent percentage.
We're going to put the child back on the stand. We're going to try to complete her examination. I've indicated my inclination. I said maybe you'll be able to talk me out of it. Right now, I'd say I don't think you will, but I don't know. And you can talk all you want, and if you want to come up to some stipulation, that's fine. But right now, just so you know, my inclination is that anybody involved in this, that anybody whose name has cropped up in this discussion is eligible for examination. And you can't leave the courtroom, sir. You can't leave the courtroom. You may leave if you leave your phone with the officer. You may leave the courtroom. You can't leave the building. She's not one of the people who have been named. Do you still have your phone on you, sir? Okay. Okay. So it's fair game in front of the jury. If you could come up with some alternative program, I'll hear what you have to say, but that I've told you what my bias is.
Okay. Can the parties speak briefly before we bring the jury out, just so that we know what we're looking at in terms of questioning of this witness on the stand?
Briefly.
Oh, you don't want to?
Meanwhile.
Oh, no.
I'm going to talk. I want to talk to everybody who's in the room right now.
I apologize. I didn't. But I apologize.
There's a court rule in effect, has been since the beginning of the trial, which provides Section 2, subsection B, cell phones brought into the courtroom must be silenced and contained within a pocket, purse, or other handbag. They may not be removed from the pocket, purse, or handbag at any time when the court is in session. Calls may not be answered in the courtroom, and anyone who leaves the courtroom to answer a call may not be permitted to re-enter before the next recess. It further provides that Section 8 violations of this order, Kenosha County Bar Rules, violations of this order, Kenosha County Court Rules, or Supreme Court rules may be punished as a contempt of the court under Chapter 985 of the statutes, which has varying penalties up to and including a fine and imprisonment for up to a year. So no phones out of your pocket unless authorized by the court. So you can confer now.
Okay, and that order that the court has done has traditionally not included the attorneys or the state's victim witness staff because, of course,
That's
we're using phones to coordinate
Yeah,
so that the
that's
court
fine.
has witnesses.
That's fine.
Okay, or the detective representative.
That's
So,
fine. And
should we go into your library briefly?
You may. Short break, yeah. All right, well, give us the report then.
Very good.
She'll put a stamp on there.
Apologize.
No, I interrupted you. Go ahead.
No, I was apologizing to the court reporter. But so we have conferred, and the parties have agreed that neither side's going to be pursuing this anymore, but we would like the court to admonish both sides of this issue to cease and desist if there's any communications or with witnesses, either on the stand or otherwise, so that, we can just move on from this. So whatever was done, and we could literally spend the next 5 days on this.
The state agrees, and we as part of that are asking that you set free the cell phones of the individuals as well.
So as I understand, and this is conclusive, final and binding, this is the last we'll hear about it. And neither side is going to raise the issue at any point.
Unless there would be new behavior.
Correct. I think that's accurate.
Correct.
And one other thing, maybe admonish Olivia about mouthing things or to her father, to our client, because that apparently has been going on. And so that's how this all sort of started in the first place.
I think the court could do that outside the presence of the jury. The court could.
I totally agree.
Yeah.
Okay, that's fine. When she comes back in, I will mention it to her. For those who are here, if we already have your cell phone, we're going to return them now. If your phone is identified as being out of your purse, handbag, or pocket, it will be collected. And I don't know when you'll get it back. So if you need your phone or want your phone, keep it where it's supposed to be, because it could be literally years before you see your phone again. Any question? Anybody? Okay. Thank you.
I'll be right back.
All right, take a short break.
Oh,
The hour has arrived.
okay, you're down.
Thank you.
Mhm. I'm okay. Thank you.
All right, let's continue.
Thank you, Judge. I'm going to ask the same question that I asked before. I believe the objection was overruled.
Can't remember that far back.
Keep question.
Yes.
Yeah, sure. Yeah.
Yeah. On May 18th, 2020, the day before your mom had gone to look for Mr. Gutierrez, your mom had told you that she was concerned that her friend was missing.
I don't recall that personally.
Do you recall your mom talking to you at all about Mr. Gutierrez the day before?
Absolutely not.
So she didn't do that?
My mother and me never had a conversation about Mr. Gutierrez ever. Except for after.
So prior to when your mom went down to Kenosha to look for her friend, she had never told you anything about Mr. Gutierrez.
In fact, that day that you're talking about, I was sitting at home. I was doing homework when I kept on calling my mother. I was trying to figure out where she is. She wasn't home on time. And I was just overall just like, where is she? And so when I had called her, she had said, you know, something happened. I'll be home shortly, and then returned about 2 hours later and told me that we needed to go to Kenosha County.
Okay, so again, I just want to be clear. Prior to that moment, she had never discussed Mr. Gutierrez with you at all?
No.
Nothing about him?
No.
Nothing about his family?
No.
Nothing about his friends?
Not like that.
Nothing about his kids?
Yes.
Okay, so she did talk to you about him.
There was a minor conversation when she had found the phone. And when she found the phone, it was that time was when I told her that I had seen a video of Mr. Gutierrez, and she tried to tell me that he was not a bad person and how he had kids and how that he just wasn't overall what my dad was saying to me about him.
So then, just to go back, she had talked to you about him.
Correct. I'm sorry, I did not remember correctly.
Okay. And didn't you also have a conversation with him after you about who he was after you were riding in the car with your mom and you saw a phone call come in that was for Junior?
What do you mean? While we were on our way to Kenosha, did Mr. Gutierrez call my mom? Is that?
No, prior to that date. Was there a time where you were in the car with your mom and Junior called her and you asked your mom who Junior was?
No.
That never happened?
No, that was a different time.
Okay, that was a different time. So
that conversation did not happen in the car.
Did you ever see him call your mom from the car?
No, not from the car.
Do you remember a time too where you...
Counsel, I'm just going to object because you stated a fact that the call that was talked about, testified to, was Leo, not Junior.
I beg your pardon?
The testimony previously that she's accessing, that she's mentioning, was a call from Leo, not Junior. So she said Junior.
I apologize. I'll rephrase to Leo. When you were in the car, did you see a Mike. You were in a car. Was there ever a time where in the car someone named Leo called your mom and you saw that?
I don't remember that.
You don't remember it at all?
I don't remember that at all.
Okay, because it didn't happen, or you just have no memory of it?
I just don't have a memory of it.
Okay. You would say you have a pretty good memory, though, correct?
Jackson, I guess it's speculative. You know, people ranking their memory. Is it relevant?
I don't remember what the objection. No, I'm.
Yeah.
No, I think most people have an assessment of their own memory abilities, and it may not be accurate, but they all have, just like some people think they're really good athletes, and other people look and think not so.
She should answer. She should answer the question.
Yes,
Yeah, go ahead.
it's been 3 years. I mean, there's a lot of stuff to remember, and there's a lot of stuff that you don't remember, and you remember some of the more important things that happened. So I don't understand what your question is.
I was just asking about asking whether you think you have a pretty good memory in general.
It's fairly decent.
Do you remember giving do you remember meeting with an individual and speaking with them about this matter in June of 2020?
Which one? There were several.
There was one where you had gone and you were in a room with just a lady. It was just you and a lady.
Okay.
It was close to, I believe, your home. It wasn't down here. She had shown you some pictures. Does that help give you a little bit of context?
Maybe.
Okay.
I know a couple of people who did that with me, so maybe. Yeah.
Do you remember her asking about what, asking questions about your dad?
What do you mean?
She asked you a question about your dad, and you had told her that you had a memory about how you were sitting in the living room, and your dad came in and said the TV's not going to raise our daughter. Do you remember telling about that memory of yours?
I have to say that your purpose is to impeach the witness. This is not the proper form of question.
It's not.
And if you're trying to refresh her recollection, then you can use a refreshment device.
Okay.
But what you're doing now is kind of a...
Sure, I understand. It's just it's a video, so I'd have to play the video.
Well, can you identify the person conducting the interview?
I don't know her name, and I don't believe the witness would remember her name, but I don't have the name. It was a forensic interview. I don't remember her name.
I saw the look on the court's face. Heard that. Yeah, Judge, I guess I'm going to object to relevancy about something that is not related to this case. An incident about TV not raising someone. Sounds potential other acts. Sounds like it's confusing to the presentation. Irrelevant.
It's not, and I don't want to say why it's not relevant in front of the witness.
Well, I don't want to hear that it is relevant without any reason for me to conclude that. I can't believe we're in a situation where we don't even know who the
It,
people involved are.
yeah, it was something that was provided late. I didn't think I was even going to have to go into it.
That's not answering my question.
Yeah. I mean, I could pull it up and figure it out if I could pull up the reports. I just don't have it in front of me right now.
Well, find it. You know, Ms. Curious.
It is a forensic interview. It's a
Well, what does that mean?
It's one of those CACs.
Yeah.
Yeah.
But we don't know who's involved or.
It's an out of county individual in a different county who is conducting an interview for entirely different purposes, is my understanding, and she's asking questions regarding other topics. And I fear that
there's no written record of it.
No.
It's a video, but
there's no written record of it.
Correct. There were no reports provided to the defense about that. It was just the video.
Again, it's document. It's an item that came from out of county.
Try to dig it out.
I am, Judge. I have it.
So
I have it here. I'd have to play it to see if I can hear the name. Can I go in the back?
Are you familiar with the particular interview that she's basing her questions upon?
I'm familiar with what she's asking.
No.
You what?
I'm familiar with what she's asking. Yes. I understand what she's asking.
All right, try again.
Do you remember telling that individual about a memory you had from when you were 1 year old?
Objection, irrelevant. Irrelevant what she thought, what happened when she was 1. Nothing to do with this case.
It doesn't seem to be relevant.
Again, I'd be able to explain it. I do not want to explain it in front of this witness for very legitimate reasons, Judge. I can approach with counsel.
You lawyers and the defendant and the witness go in the library and have briefly tried to get to the point we need to get to.
And the witness. Want the witness. I'm confused.
I don't want the witness and the defendant in the same room. Is that what the court? I don't know what the court suggested precisely. I thought you were just saying the lawyers should do something. I apologize.
Well, I was trying to avoid sending the jury out of the room again.
Totally understand.
No, we can go back. I was just saying I don't think the witness needs to be back there.
He can remain out here for a second.
That's fine.
But you lawyers go back there and see if you can bring this to where we need to be. And you can go with him, Mr. Anderson, please. You don't want to? He's waving me off and saying he doesn't want to.
Thank you, Judge. Because of potential issues down the line, and what the state then would try to get into, and we've decided to not go down this road and to move on.
Any comment on that?
Council can make her own record about what happened. She's indicating she's not going to go on. So
All
that's
right.
fine.
Thank you. So after, so before you talked about how you never talked about your mom about who Leo Jr., Mr. Gutierrez was, but now we've heard there was a time where you were in the car that Leo called and you had a conversation about who he was at that point or soon after.
Okay. So the question is argumentative. To indicate she first said something and now she's saying another is an argumentative question.
Well, it's overall.
You can answer.
Repeat your question. I don't understand.
Sure. So you're in the car. You see that this phone call comes in from Leo, right?
She indicated she did not remember that. Objection, that's been asked and answered.
Yeah.
I thought she
Well,
said.
I thought she just nodded her head yes. Did I see wrong?
No. What?
What's?
I don't remember that.
Okay.
Well, and I apologize. I thought previously you said you did remember receiving that call, so that you don't remember happening.
No.
So how about a time that you went through your mom's cell phone and saw a text with Mr. Gutierrez?
What are you asking about that time?
Did that happen?
Correct.
And then you confronted your mom about him then, correct?
No, I did not.
You didn't have, and she didn't have a conversation with you about that?
No.
Okay. So after your mom goes down to Kenosha, she comes back and she tells you about what she thinks happened. Did that happen?
We're on May 19th now?
Correct.
Okay.
I just didn't know if I say May 19th, would you know what day I'm referring to as to what occurred?
It wasn't about what she thought had happened. She came in the house and told me, I think one of my friends was hurt pretty bad. And that's really all she had to say for me to get it.
What do you mean for you to have to get it?
To understand what she meant by that.
And what did you take that to mean?
Can I skip this question, please?
I'm afraid not.
I knew something bad had happened to a person who I knew about, who in my head I knew about.
So in that moment, you knew that your mom basically was telling you something bad had happened to Mr. Gutierrez.
She didn't really specify names at the time when she just said that, my friend was hurt pretty badly.
I'm saying not about what she said, but trying to clarify more what you took it as. So when you said that you knew someone was hurt really bad, did you think that someone was Mr. Gutierrez?
Yes.
Why was that?
From what had happened on my birthday morning.
And you knew that your mom had gone down to Kenosha to Mr. Gutierrez's place?
Absolutely.
So she told you that?
No.
So how did you know she went there?
I was tracking her.
You were tracking her?
Correct.
How were you tracking her?
On Dad's laptop, on his desk.
So you had access to your dad's laptop on his desk on that date.
I did not log into it. He set it all up, and I was sitting in front of it, and he was taking care of the boys downstairs.
So this is on May 19th?
No.
I'm talking.
Sorry. No.
We were talking about May 19th when your mom came home and she had told you that something bad had happened to her friend, and you said you took that to mean something bad had happened to someone, and that I had then asked you if it was Mr. Gutierrez that you thought it was. You had said yes, because of what had happened. I then asked you how you knew your mom had gone down to Kenosha to go check on Mr. Gutierrez, and I asked you if she
Sorry,
had
I
told
didn't understand your question.
Okay. So back to May 19th, 2020, how did you know your mom was going to Mr. Gutierrez's apartment?
I did not. I had just come home from school. I was doing homework.
Who was there with you when you got home from school?
No one.
And so you didn't know she was going to see Mr. Gutierrez?
I had no idea. And, it wasn't very uncommon for me to come home and my parents weren't there. So I didn't really think anything of it until hours started going by.
I want to go back to your answers, though, that you were giving before about being on your dad's computer, on the desk. We were clearly not seeing eye to eye there, which is fine. What date were you referring to when you were tracking your mom?
In between my birthday and Mr. Gutierrez's disappearance.
So
I don't remember the exact day.
Okay. And was that the only time you went on your dad's computer?
Yes.
And when you went on his computer, did you have to put in a password?
No, like I said, he had already logged into the computer and it was all set up. He just basically told me to watch where she was going.
Okay. Did you take any screenshots when you were doing that?
No, actually, I didn't have a phone like that.
Oh, so
I didn't have the ability to do that.
So were you on a phone or were you on the computer?
I was on my dad's desktop, but I did not have a phone to screenshot anything or screenshot anything on that computer.
Was it a desktop or a laptop, if you remember?
A desktop.
And after going back to May 19th now, I'm sorry to take that little detour. I wanted to clarify what you were saying before. On May 19th, then, when your mom came home, then you went to the police department here in Kenosha?
Correct.
And during that car ride, you talked about what was going on and what was going to happen, right? When you arrived at the police station.
I don't quite understand.
When you were in the car ride here, was it explained to you about where you were going and why?
Briefly.
And what did you understand you were going to do?
Well, my mother didn't know this at the time, but I understood what was going on. I understood more about the situation, and when we got there, you don't really have a choice. You kind of just have to go in there and tell.
And you previously had said that your mom didn't really talk about Mr. Gutierrez. And you also said that you had talked to your mom about the events that happened the night of your birthday, the early morning hours of your birthday day.
Eventually, yes, I did. I had very traumatic experiences from that. So, yes.
When did you have those conversations with your mom, if you remember?
Just objection, just as to vagueness. Are you referring to discussions about what happened on her birthday night, that the April 24th event? I just
Sure.
I'm confused about what you're asking.
Sure. Well, I guess it's because
If
you're saying there was no times where your mom discussed Mr. Gutierrez with you, correct?
I disagree.
So were there times where you brought up Mr. Gutierrez with your mom?
Yes.
When, do you remember when?
It was not before all of this.
So it was only after.
Correct.
And when I said after all of this, I don't want to put words in your mouth. So if you could just tell me, like,
After
when,
my dad was arrested, when we were sitting.
okay, so you only told her all the details about
After.
everything you knew after.
Yes. I did not tell her everything.
Do you remember, so now on that May 19th date, when you're here in Kenosha, you're having the interview with detectives, do you remember having to stop or asking to stop the interview to be able to go ask your mom a question?
Yes.
And when you went to go speak with your mom to ask her a question, it was about whether you could, and without going into the details of what it was about, whether you could go into something with the detectives.
Correct.
Soon after that May 19th date, and I'm going to give you a date. If you don't remember, that's fine. Just let me know. But on May 22nd, 2020, do you remember meeting with or speaking with a detective over the phone?
That possibly could have happened, yeah.
Okay. And in that phone call, you were talking about your dad's flip-flops. And so we have those now, and I just want to show them to you. Her.
Uncle, I'm just going to ask you not use the name if you can help it. Yeah.
Sorry.
Yeah, it's
It's
hard.
not like I
Yep,
try.
absolutely.
Okay. I'll show you one of them.
Yeah.
Pretty documented. Yes.
Do these look like your dad's flip-flop? Okay, the ones he'd wear in weird ways.
That's probably why they look like that.
Yeah, okay. And these were the flip-flops he was wearing on the 16th and 17th.
When I saw him
When,
last.
yeah.
Correct.
Does it add move into evidence defense exhibit 319?
No objection.
Then, after May 22nd, 2020, again, I'm going to give you a date. If you remember, it's fine. If not, it's cool. November 6th of 2020. Do you remember Detective Anschutz coming to your mom's house?
Yes.
Okay. And do you remember in that interview telling Detective Anschutz about the phone that your dad had given you, the Motorola G6?
Yeah.
And your testimony is that your dad had given you that phone?
Yes.
Didn't take the phone without his consent?
No.
Were there times where you had taken during this time frame, were there times where you had taken people's phones without their consent?
Objection, Judge. It's improper impeachment of this witness, irrelevant.
Rephrase your question.
During this time frame, you had taken a phone from a family member, correct?
Again, Judge, this allegation is irrelevant and is improper impeachment.
Overruled.
Go ahead. Yeah, does she know to answer?
Yeah, you can answer it, sorry.
Yes.
That was yes?
Yes.
And do you remember in that interview as well telling detectives that actually, I want to go back to the chainsaw statements that you were talking about earlier. You had said that what happened, can you walk us through again what happened with that chainsaw when you got to the tree farm on the 16th?
He took it out of the back trunk and he walked it into the barn and they were looking at it. They meaning my dad, my grandpa, my uncle, and so who's there and me.
And you told that to the detectives when Detective Anschutz came to your house. That's when you gave him that statement, right?
Objection. How would she remember what statement she gave certain information in? Relevant.
Well, overruled.
Sorry, you can answer it.
I'm not sure I understand what your question is.
You had told detective, maybe you don't remember when or with what detective specifically, but you had told them at one point that your dad took the chainsaw and out of the vehicle.
Yeah, and took it out of the vehicle and took it into the barn.
And then did he put the chainsaw then back in the vehicle?
Correct, and we took it home and then he took it out once we got home.
The same one?
Correct.
Do you remember telling detectives that your dad took a different chainsaw home with them when they left and left the original one there?
It could be that I said that, yeah. I don't remember.
Is that what happened?
I'm not sure if that's what I said originally, then that statement probably has the best memory.
So your memory today then is that you're not sure actually what happened with the chainsaw?
I have recollection of it being taken out and put back into the vehicle.
The same one?
Same
I'm not
vehicle,
sure.
same chainsaw.
The same chainsaw?
Possibly.
Okay. But you're saying whatever memory whatever you told detectives closer to that date would have been the most accurate thing?
Correct. This was 3 years ago.
Understandable. Do you remember telling law enforcement that your dad had a storage unit?
No. I do not remember that.
Does your dad have a storage unit?
I have no idea.
Do you remember detectives asking you about the money that was in your dad's house?
I do.
And you told detectives that he would usually have a lot of money in the house and that you would count it, right?
I have counted that money before, correct?
Well, the question was whether you had told the detective that,
Oh, sorry, yes.
that your dad had a lot of money in the house.
Yeah.
And that you would count it.
Yes.
Do you know anything about psychedelic mushrooms?
I do.
Do you remember telling the officers about your dad experimenting with them?
Actually, I do, correct. The mushrooms in the fridge was actually what I was referring to, and I had found out that he was not selling those and that he was taking them himself.
And you knew, though, that he was selling the marijuana.
I did know that.
So enough about all the detective talk, just some basic things about your dad and his house. A little bit more casual. He was trying to do work on the house, right?
The work was under construction, yeah.
And you would still go over there and play with your brothers and have a good time.
Yeah.
Skateboard, play basketball.
Yes, there were a lot of bad times during our family situation, but there were also good ones too, and the ones that you're mentioning are definitely good ones that I've had with him, yes.
Yeah, and having bonfires in the back.
There's tons of good memories there. Yeah.
Would you have bonfires there?
Yeah. I mean, it wasn't very frequent, but I mean, yeah.
And maybe it wasn't frequent because you weren't there every day. You'd go over. Let me just ask you, how often would you go to your dad's house?
What period? Just so
during the period we're talking about. So from like March of 2020 through to the last time that you were there.
I couldn't count how many, but there were very many times, barely many times that I was over there.
And were there times where your dad would come over to your mom's house too, and you guys would hang out there as well?
Yeah. It depended on the situation in the day.
Yeah. So you were talking about how your dad would sometimes be over at your mom's house and that there would be certain, different reasons why.
Yeah.
Did your dad still have any belongings at your mom's house? If you know.
Maybe. I mean, my dad also traveled for work. So while he would, in between coming home and leaving, he would stay at his house. But when he would come back in town, he would stay at my mom's house. He would just sleep on the couch. So, I mean, I'm sure there was some of his stuff there, maybe still.
Okay. And by stuff, I mean like some clothes, maybe.
Yeah.
All right. No, nothing further subject to recross. Thank you.
During this time period of, from the date of your birthday until Rosario Gutierrez went missing and you came and spoke to the cops, was the defendant spending any overnights at your house during that period of time?
Not that I recall, no.
Okay. And when you were asked about a storage unit and said you don't remember anything about that, do you remember telling a detective that the defendant had told you once he had to go leave to go to a storage unit one day? Do you remember saying that to a detective?
Could have happened. I don't remember saying that personally, but maybe.
You were shown a pair of flip-flops. Did your dad have, during this period of time, did the defendant have multiple pairs of flip-flops or just one single pair of flip-flops at a time, if you know?
I'm not sure.
Okay. And you were asked about the interview with law enforcement where you asked for a pause and you asked if you could go ask your mom a question. Do you remember that?
I did.
What was the topic that you wanted to ask your mom if you could bring up to law enforcement?
I'm going to object to relevance. I specifically, when I asked the question, asked her not to go into details of what that was about.
Right. So right now it's left as something suspicious. She should be able to give an answer about what it was. You can't more clearly open the door.
We're going into other acts of evidence, Judge.
Well, I don't know.
I know. I know.
Well, actually,
Judge, let me just say, it's the same stuff we've talked about already. It's the same.
No.
Okay.
Let's take a short break, 10 to 12 minutes. Please can talk about the case during the break. Read, watch, or listen to any account of the trial. See you then.
It's in a transcript, so we actually, all parties know what the interaction is. Counsel provided me a transcript that has the interaction. And then when she came back out, that's when she began to talk about the marijuana grow. So what she's about to say is...
Yeah, no, that's not what she actually went to talk to her. It was partially what she went to go talk to her mom about, but it was about an unregistered gun in California. That was the main point of it. That's what I have an objection about. If you want to talk about the marijuana stuff, be my guest. We've already had a ruling on that. But I think as far as an unregistered gun, that hasn't come in at all, and that it wouldn't be relevant at this point.
Agree. And so if you would just caution her to not bring up the gun and only bring up, I mean, her answer will be a simple answer. I've already talked to her about the marijuana. I'm not going to go into detail again.
But it wasn't.
Redirect. And I understand, counsel, what your concern was. But if you simply indicate to her, please don't mention the gun, I think she'll simply answer, I came back in and spoke about the marijuana that was being grown at my dad's house. Then we'll be concluded with that. We'll have an answer to that question. We'll be able to move on. I'm almost done.
But that wasn't, she only asked Sadie about whether she could, and she's here, she can speak for herself, but that whether she could go into the details about the unregistered gun. Sadie then said, what? I have no idea about that, but you should tell law enforcement whatever you think you should be told. Then she went back and talked about the unregistered gun. She was already talking about the marijuana. That wasn't something that she sought or ran through with her mom. It was my understanding and how I watched the video when she goes into the room with her mom. It's about the gun.
So, Your Honor, I don't understand how counsel asks the question on May 19th. Did you take a moment to ask if you could talk to your mother? And then did you go talk to your mother? And then did you come back after speaking to your mother? The answer, so those were the questions. How is that not opening the door to another discussion? When you ask all those questions preliminarily, you don't get to just live with an answer that is not accurate and is the most suspicious answer, would be my retort, right? So I'm simply telling the court, I am willing to defer and not go to the gun because what she did then was do almost all of her substantive discussion about the marijuana. But it is true that she came back and also talked about an unregistered gun. I'm not asking to bring that up because from my perspective, the marijuana is answer enough because I don't think she gave virtually any marijuana evidence until after that break. So I'm not even, but you can't more clearly open the door. That's all. Thank you, Judge, for letting me argue that.
What is the objection that's being made? Is this for some prophylactic purpose, or is this
what I'm soliciting? I'm not even sure they're opposed to it at this point.
I am opposed to it.
Well, go ahead.
Sure. I am opposed to the representation that she went there to go talk about the marijuana because that wasn't why she went to go talk to her mom.
Now I understand that. So now understanding that, I am asking to bring in the unregistered gun because counsel believes that is the answer to the question she asked of the witness. She asked, and so I went through all those questions to the court. The answer is she came back and wanted to discuss an unregistered firearm and a marijuana grow operation. The jury's already heard about the rest of it, but what was solicited by the defense was on May 19th, did you ask to speak to your mom and take a break? Did you have a meeting outside of law enforcement to take that break? And then did you come back in and only after that break? Suggesting that Sadie Beacham has improperly suggested information to her, right? That what a jury would conclude reasonably from that exchange?
Well, I think there's been times a lot during this trial where we recognize as practitioners that there are certain details that would not be admissible, and we've asked questions in the way of, without going into the details of what that was, just like with Marquand Washington, without going into the details about what your conversations were with Mr. Anderson. Did you have conversations with him about certain things that you bonded over? Yes. So there's always going to be things that potentially there's a lingering, oh, what was that about? But when we look at probative value and other acts evidence and whether it's come in, I don't think that here, when my question was, I did ask that question and I specifically said without going into detail. But I don't think that it's relevant. I don't think that its probative value outweighs the prejudicial effect.
Why are you asking these questions? What is your purpose? Because Mr. Gravely makes a perfectly good point. That when it gets just dropped there, it leaves a very different message for the jury.
Well, when it just gets dropped there about things that the state's witnesses did, that leaves a bad image for us too.
Why don't you answer the question I asked?
I asked it to go along with our theory of defense, and I'm gonna leave it at that.
Which is Sadie Beacham put her up to it. That's the theory of the defense here. And so the truth, the honest answer, which we all know. I mean, this is a transcript, right? So counsel knows the answer to that question when she asked it. It's not like this is an unknown answer. We all have a transcript. she wants to create this suspicion, but not have the honest answer in front of a jury as to what that's about.
But I'm
So-
at this point, I guess, what is an anticipatory objection.
She's objected. The true answer to this question
Well,
is
I don't think I didn't necessarily, we kind of took this as an offer of proof.
but
Fine.
Counsel, you objected to me asking what did you come back and say? That was the question you objected to. So the true answer to that question is what I came back and said was that my dad had an unregistered firearm in California, and I talked about his marijuana growing operation, right? Those are my words. That's my paraphrase. But that's what she came back and talked about after asking her mother. And we have a transcript of the dialogue with her mother. So we all the parties know what was said in that room when the cops were gone. And you know what her mom said, Judge? Her mom said, if I didn't even know about that thing you're talking about, just tell the truth. That's what the mom said. So those are the true answers. So at this point, I'm asking the court permission to have her answer truthfully because the door was busted open, and let her say, I'm aware of an unregistered firearm he had in California, and I'm aware of the marijuana grow operation. That's what I asked my mom, whether I should talk about.
Well, go ahead.
Okay.
Well, I guess this was a regular break, wasn't it?
You want us back
Oh, about
15 minutes ago? 4 days ago?
yeah. In about what's that?
I think they're just sitting.
I think I took a break, so yeah, I think most of them did. Yeah, she says only one.
So when are we back?
Let's start at 20 after. And that clock is not accurate.
7 minutes.
Okay.
I'm with you.
Are we down to a one-person jury at this point?
Here we are.
Because I wouldn't blame them.
Found the escape route on the
Yeah.
third floor.
You should have never let them have that back exit, Judge.
Ah,
They found on the roof.
Now you're giving them ideas.
People, don't say that, people will leap off.
that used to be open. You could get up there on 4th of July and watch the fireworks. But then they locked it up.
Yeah, what year was that done?
I mean, that's going back a few years. Go ahead.
Why they can't?
So I was, when I last was talking to you, I was asking you about a moment on the May 19th interview where you asked for a moment to speak to your mom. Do you remember that?
Yes.
And when that happened, was it just you and her in a room for a while?
I want to say like not for a little while, but like a couple of seconds. Yeah.
Okay.
Maybe a minute.
And did you ask your mom for some advice?
I did.
Okay. And what was your mom's advice to you?
To absolutely tell.
Okay.
what I had asked her.
Okay. And so when you came, so at that point, did law enforcement come back in the room?
They told me to go back into the room, and then they kind of left me there for a little bit and then came back in and talked to me.
Okay. And when they came back and talked to you, and during this interview that we're talking about, your mom's not present, right? While this particular interview is going on.
No.
Okay. So when you came back, what was the information then that you wanted to then let the police know after you got back in the room?
I did tell the detective about the unregistered gun in California.
That who had an unregistered gun in California?
My dad.
Okay.
And then I also had talked about my dad growing and selling.
Growing and selling what?
Marijuana.
And that was at the residence?
Correct.
Now, you were asked a question previously on a cross-examination where you said that you had told your mom at first that you weren't there at her house on April 24th, the night before your birthday. Do you remember?
I was not.
Okay. I'm sorry, what? Do you remember telling her that you weren't there? You didn't, in other words, that you didn't do the peeking in the window personally?
Oh, yes.
Okay. And so I just wanted to ask you why you originally did not tell her that you were there. Why did you not want to tell her right away that you had been actually present?
I don't think that we can go into character. Is that? I'm not sure. I don't know how to answer this question without his character being involved in it.
Well, actually, if that's what his lawyer's job is, to object if she feels that the answer would get into that area. Sometimes character evidence does come in during a case. And it happened earlier on. I'm not sure if it was while you were here or not, but I made a special instruction to the jury that the evidence is not received for the purpose of showing that the defendant has a character trait or character, and for that reason is likely to have committed the crime charged. This evidence, for example, this reference to a firearm in California. And by the way, some of those laws have been ruled unconstitutional, but that's not really directly on point here. But it doesn't bear on whether he's committed the crime charged in this case. So I will instruct them now that they're not to consider it in deciding that he's a bad character and for that reason is more likely guilty of the crime charged against him. Any question about that? So that's my job in taking care of the character issue. You can just answer the question.
Okay.
Should I repeat the question or do you remember it?
You can repeat the question.
Okay. So my question was, why did you decide not to tell your mom right away that you had been present on April 24th and peeked in the window?
So growing up, I definitely groomed. So
I guess I'm going to ask that be struck.
She said she was groomed?
Sure, it's almost a legal conclusion.
Redirect.
Okay, I will do so, Judge. Thank you.
You can go ahead and answer.
Or recross.
I was basically controlled to do the things he was asking of me or instructed me to do. So I didn't have that freedom, if that's what you're asking. I still thought I wasn't allowed to talk to detectives or cops or any of that sort. So.
Okay. So now I'm asking about so this is a different question now. Okay. So the topic now is that you were asked on cross-examination, did you discuss with your mom a bit the what had happened when in terms of your dad looking in the windows and people looking in the windows when she and Rosalio were at the house on April 24th? Okay, so you said I did discuss it with my mom a little bit, and then you said I told her I wasn't there. So you at first you told her you weren't there. You didn't look in the window yourself. Okay, and so my question was, why? This is about your mom. Why did you choose not to tell your mom that you were there and peeked in the window at first?
Because I was still under my dad's mentality.
I have no further questions.
Cross?
Yeah, thank you. The state asked you on redirect about different times you talked to law enforcement again. There were times in this case, though, where you not only talked to law enforcement, but the district attorney, correct?
Yeah.
And you've had meetings at the office to go over your testimony several times.
Not like that. I think it's the same way that the DA meets with their clients. I think there's not, we didn't discuss, I think we're discussing something.
No, I asked you, I'm sorry. The question was whether you met with the district attorney, you, not other people.
Yes.
Whether you met with the district attorney several times to discuss your testimony.
Not about my testimony, about the general.
Several times.
I cannot give you a number.
When you were at those meetings, you didn't talk about your testimony at all.
What do you mean by that?
You didn't talk about what you were going to say or what questions were going to be asked. None of that was touched.
I mean, to me, I think those are pretty fair questions to ask if you're a teenager.
So they were asked then?
I mean, yeah, if you're a teenager and you're being put on the stand, what are you going to ask?
What the attorney is asking.
Yes. My answer is yes.
You don't have to justify what happened. In fact, I'm going to tell the jury, actually, that it is quite common. In fact, it's expected that attorneys will meet with witnesses as much as possible before the trial for a large variety of reasons. Oftentimes, it reduces the number of breaks that the jury has to take. So that the lawyers are acquainted with what can be expected. It, over the years, sometimes develops a bad name of coaching, which is suggestive that witnesses are told to say things that are not accurate. That is not permitted. But it is normal for the district attorney to meet with the witness or witnesses and the defense attorney as well. Okay, any question about that? Okay, go ahead.
In meeting with, basically what I wanted to get is, you met with a lot of people many times.
Correct.
You talked on redirect about the unregistered gun in California, but you never saw that firearm, correct?
In what circumstance?
The unregistered gun was in California, right?
At one point, yes.
So you're saying then the gun wasn't always in California?
No.
What kind of gun was it?
Do you know?
I'm not aware of guns like that. I don't handle guns like that.
You said guns like that. What do you mean?
Meaning, I don't know. Meaning, I'm not familiar with guns like that, but I can tell you there was one.
What color was it?
Black.
Was it long, short? Can you describe with your hands?
It was short. It wasn't. It was probably a pistol of some sort. I'm not sure.
Okay, where did you see it?
It was at the Mech One house.
So you say that this unregistered gun is in California to law enforcement. Up until today, did you ever say anything about this gun being in Wisconsin?
When I had talked about this gun, there were other traumatic events going on in my life. So this isn't.
You don't have to defend your answer.
I'm trying not to defend it. It's what happened. It's legitimately what happened. Like, there were other things going on, and this isn't something that's related even to this situation.
But if you
It's
listen,
not.
and I'm not, don't take this as a scolding. I'm saying, listen carefully to the question and just try to answer just the question. And if there's more to be gone into, the lawyers will usually cover it.
I was threatened with that gun, for your information.
Judge, I'm going to ask that be struck. That wasn't my. That wasn't.
No.
Repeat your question.
It will come as no surprise to you that you're going to go into the library for a moment. Okay, what's up? I think I need to know more before I go any further with this. Would you talk into the microphone?
It had nothing to do with this situation. It had something to do with, I don't know how to answer this question.
Okay.
It's a hard question.
See if there's any lawyers in the hallway. Well, I want to let's see what's going on. Are you familiar with what's being discussed?
Yes, in the most general terms, and certainly we don't expect to go into it.
I was just.
Given how she's feeling right now, I will just leave it. I won't ask any further questions about the firearm.
Will that be the end of the discussion on this, or is there going to be more?
No, I don't.
I don't mean questioning. Is there going to be more? Is it going to play a role in the case at any point?
Well, I don't intend to. I never intended to bring up anything in any of these areas, and I don't intend to now.
I didn't either. That's why I asked her not to go into any specific detail.
Mr. Barth, would you come up, please? Isn't that Mike Barth back there?
Yeah, it is.
Come on up, would you? Would you come up, please?
No.
Would you do me the favor of taking on this lady as a client?
I certainly would.
All right. I'm going to appoint this man to represent you. Not that you need a lawyer, but to give you advice about how the law works if you have questions. Okay? His name is Michael Barth. And is the jury in the library?
The break room across the.
Yeah.
Take her to the soda room.
Thank you. Yeah.
Wait, I just don't understand why. I mean,
Thank you. Okay. What she's talking about?
I'm honestly not, because this is new information about this firearm being here. This is the first time I've heard about this.
State, are you familiar with what she's referring to?
She has what?
Yeah, so in the most general terms, when we had met with her one time, she had discussed the firearm piece and then had relayed to us briefly a traumatic event surrounding the defendant, that firearm, and herself. And so that's
And it's not an incident near in time.
correct.
It's not
It's not what?
it's not near in time.
It's not near in time to this time frame we're talking about. It was, removed from that. So
Yeah, I have no idea about whatever the state's purporting. It was never told to me.
Well, apparently the state doesn't think it's relevant. So I don't know if they would need to, but,
That's fine. I'm just giving the court context because obviously I was just going into it because the state brought it up and I just wanted more answers. I didn't know asking this line of questioning, it would lead to this because I didn't know of this situation that they're claiming.
well, the question is now how to handle that with respect to the jury. And I guess if it's irrelevant to this case, then the jury could be so informed. She hasn't accused anyone in the presence of the jury as to having threatened her with a firearm. Am I right about that?
That's accurate. So maybe a curative instruction or just something simple.
Is everybody okay with that?
A curative instruction that would say,
Just tell I would just tell the
The
jury.
testimony about the gun is irrelevant and you should disregard it. And
well, it's not irrelevant in the one aspect, which is it was something she was concerned enough about that she asked for her mom's permission to talk about it. But what she just described in terms of circumstances with the gun is something that the state believes is irrelevant.
That the state believes
Is irrelevant.
okay.
Then I'm going to ask.
Go ahead.
Sorry, Judge.
That's right.
I guess let me hear what you're going to propose first. Because I don't want to say something if it's good. Yeah.
My inclination is to tell the jury that we've gone to further depth in this subject, and that the statement that there was a threat made involving the firearm, it's not relevant to this case. There are no further details about it that would be relevant to this case, so that they should disregard it entirely.
I agree.
But those who agree are going to be bound forever to this agreement. So it's not going to be an issue that's going to pop up at some later time. Talk it over. Right now, you, second row of, no, come forward, more. Right there, out. You're leaving. The spectator was reacting to the remarks which were being made, and I think it made pretty clear I wasn't going to tolerate that. Okay. It wasn't terribly disruptive, and the jury wasn't here, so if he returns tomorrow, he'll be allowed to come in.
No. Alrighty.
I beg pardon?
An instruction that simply says, this line of questioning has been deemed irrelevant.
No. That was not what I proposed. That what the witness's last remark regarding a threat is agreed as irrelevant in this case, and the jurors should disregard it. That statement. The line of questioning was not contaminated. It was strictly what the witness said, and I'm not saying even that was contaminated. It's that particular comment, I'm told, is irrelevant to this case.
Yeah, my only question is, does it suggest that the witness has made some mistake by answering that way? Because I think the answer was a logical answer to the question. So I don't know if it suggests that to the jury.
And Judge, what I'd like to chime in here now is that obviously the defense objected to going into this unregistered gun in the beginning. Just got in, the state asked it. I asked some follow-up questions on it. The state knew all these things about what she had told them about this particular incident.
Actually, the question right now is whether you want to agree to.
I do want to agree. I was just trying to make a record, Judge, from the defense's perspective of the state. It's fine. It won't meet it.
I applaud you for making your record as an attorney, but I also put in this stipulation that this closes the matter out, and it's not going to be the subject of any attention from the court hereafter. If everyone agrees it's irrelevant, that this to be disregarded, And it is, that's in no way suggesting the child has not testified truthfully, only that any threatening behavior was not, is not, does not involve the defendant.
That's not true.
Yeah,
The threatening
That's not
behavior-
true?
The
Well-
threatening behavior is alleged to be from the defendant.
Correct.
Not according to the testimony.
That's not what I,
It's not that was not the testimony.
What-
So
What was the testimony?
the testimony was that she was threatened. She didn't say who. She didn't say anything. There's no factual basis for that whatsoever.
That she was threatened with that firearm.
With this
she
firearm.
said she was threatened with that firearm, and then I excused the jury.
Right. Okay,
And
so,
I did not, after that, hear any reference to the defendant having been associated with the threat.
okay,
And I interpreted what you said to me to confirm that. And then I thought, well, he's the DA. He'd know. But of course, you weren't the DA of wherever the threat allegedly took place, which is, quote, Wisconsin. But
okay. Well, so the current state of the record is she says, I've been threatened with this firearm, but it doesn't say who threatened her.
correct.
I see.
So I intend
Is that
to,
your recollection?
To be
I
honest with you,
I took it as that she had said he threatened, but I may be wrong.
I don't recall
Okay.
hearing that.
You're definitely wrong.
Okay, here's counsel.
I'm wrong?
No.
We are wrong. Okay.
You're never wrong.
I'm not used to being
No.
told that.
No, I would never, ever suggest that. But I think the way you phrased it was accurate to sort of summarize it for the jury and then say disregard it and it's irrelevant to this case.
Okay, I'm going to try it again now. And this is if you agree to it. If you don't agree to it, by the way, the alternative is that we'll have to address it. I can't just leave it out there. So what I propose to do is to tell the jurors that the last response that was made by the witness, we've examined it and the circumstances, that it is irrelevant to this case, and there was no accusation as to whose conduct she was describing when she referred to having been threatened.
I want to. Questions at all. So I don't, if the court, is the court saying that because you think it provides them some ballast for then what we do? Because I, as far as I know, we have not examined the details of what she is saying happened in that regard, right?
Well, first of all,
I mean, I've just,
First of all, if we do examine it, and it turns out it does involve the defendant,
right.
tell me how to avoid a mistrial.
Yeah, no, I understand. I'm just
Okay.
I'm just trying to get wording that is fair. I got where the court is.
I think an even cleaner way to avoid a mistrial is to just strike that entire question and answer, period.
About
Just, yes, the reference to that, and just strike it completely.
So we don't agree to that, but we are willing to strike the last question or two.
No.
But the unregistered firearm was brought up, and the court has already given a cautionary instruction to the jury verbally about that. So they brought up, they opened the door. The state is not willing to leave a discussion under cross, as we described before, where the accusation is that there's improper discussion when there is an honest answer. But if we wanted to simply go back a couple questions in the inquiry from the defense and strike those and indicate the jury is to ignore those questions and answers, I'm agreeable to that.
This is why there acts evidence coming in when the state talked about how they want to ask about this gun. And the problem with them knowing this information because of a conversation they had, and the defense then left in a situation where the jury hears about an unregistered gun. Maybe I should find out a little bit more about that. And then it leads into this. I think because the witness has testified that Mr. Anderson had an unregistered gun in California and has now said that when this gun was here, allegedly, she was threatened with it, that the inference that's going to be left with the jury is irreparable if we do not strike everything about that unregistered firearm.
Well, I don't agree with that about the irreparable part. I don't agree with Mr. Gravely's suggestion because I did think that, well, I'll leave that at that. I am going to tell the jury that the last remark, which was made by the witness, does not relate to this case. She did not identify any specific person as having threatened her with a gun. And so it should not form any part of their consideration about this case. He thinks it is appropriate to share with you, and there may not be, then you'll know more. Or perhaps he won't share any. We'll find out.
Just on the point of the court's proposal, and I think an addendum to that, excuse me, would be to not only give that instruction as to however many questions it was, but also to, because there's a serious slippery slope taint here, suddenly introducing a firearm into this, and to prohibit them from arguing about the firearm in their closing. Even though it's apparently some of that.
I don't want to get into a negotiating session and try to handcuff the district attorney. Either you agree to it or not.
Well, let's
And we'll talk with Mr. Bard.
We'll confer.
And I will tell you, as I said a moment ago, one of the possible outcomes of this is a mistrial. I'm not telling you it will be. I would sleep on it before I make a decision like that. And I probably wouldn't want to do a cram down on anybody either, but be aware, you may end up there.
Understood. We'll confer.
All right. If you don't mind the jury's overhearing what you say. No, they're yeah.
So
Unless Mr. Barth deems it necessary to give a report, he need not do so. Okay. What's your position?
State's position is that we believe that what the court has proposed is appropriate.
Agreed. And, yeah, we'll move forward and I think we're close to,
I think we're done. We're
I
gonna
think we're
just be
done.
done.
With the witness?
Correct.
Okay,
And I don't think you have any
That's correct.
okay. So let's review one more time. I'm supposed to tell the jury that the last remark made by the witness with respect to having been threatened with a firearm as is irrelevant to the case and has nothing to do with this trial at all. And there has been no accusation as to whom the person doing threatening was, and so the jury should disregard it entirely, and it should not form any basis for their evaluation of the case.
Agreed.
Sounds good.
Okay, and this also closes this up, and I don't expect to hear later, at any point, any later complaint about the resolution of this matter.
Understood.
Thank you.
Okay.
Put the witness back up there so we can.
If she's comfortable, but it isn't necessary.
She can stay where she's at. Okay. Won't we both have to say no further questions?
That's
Yes.
fine, but I don't think she.
But you can do that. She can stay where she's at.
Very good.
Ask the jurors to come in, please.
No, I think they're.
And I suppose you guys,
Yeah, stay back there.
I suppose you guys want to finish up now for the day.
Put her back up there.
I'll go to midnight if you want.
You probably would.
Don't ever leave.
Oh, gosh.
Enjoy the moment.
Yeah.
Yeah, right?
Just before you left, the witness made a statement about having been threatened with the firearm, and that does not pertain to this case at all. There was no accusation made about anybody involved in this case, and so the incident is not relevant to this case in any respect, and what was stated should not have any effect in your evaluation of the evidence in the case when you go to deliberation. Any question about that, anybody? Okay. Who feels that you've earned the rest of the day off? I think he speaks for the jury as a whole.
We indicate we
Oh, yeah. Someone's jumping the gun here. It's my understanding.
I have no further questions. I'm done questioning that witness.
I have no further questions regarding the questions asked of counsel.
All right. So they've given me the okay to call it a day. And let's assemble tomorrow again at 9. Please don't read, watch, or listen to any account of the trial. Don't discuss the case with anyone, not even fellow jurors or household members. And any question? Okay, have a great day. The clerk assigned here, Paula Audley, attempted to address me about some incident involving the defendant and the child. And well, I couldn't hear her to begin with. The hearing is terrible in here. So I asked her to send me a message, which frequently is what we do. And I provided copies to you. Comments?
So, 3 hours. My opinion, giving a definitive order to the parties that they were not to communicate with a specific witness. The court now sees a second incident where not only, where essentially the same conduct has happened, witnessed by a neutral party. And I asked the court to at this point, take remedial action. I think the court should consider all variety of actions that the court feels appropriate. But this is a direct violation of what I believe to have been a court order. And I don't know how the court could have been more clear, and I don't know how the disobeying of your order could be more clear. And, this is a court of law. It's a jury trial. It is a very difficult, impressionable witness who, even in the face of a court order, had this behavior that they faced again. So I asked the court to impose a sanction that the court feels is appropriate and to take remedial steps to prevent this sort of blatant violation of court orders. Of course, this has nothing to do with the attorneys, that there's only one responsible party in this room in this situation. And certainly I intend to impeach with this or think about how this could be utilized in the trial, but that will require a little bit extra thought. But at this point, I asked the court to, a simple warning has not been enough. So I asked the court to think about what should be next here.
So Mr. Gravely's prosecutorial side is clearly coming out here, and he's seen a lot more in this than I think is there. So first of all, I'm just reading from the document that was given to me that he was, the clerk says that he was facing the daughter's direction. Well, we don't know if the daughter saw anything, number one, and gave her a scowling look, and was mumbling. Well, we don't know if he was mumbling to himself. And we don't know any of that. We don't know if there was an attempt to communicate. So Mr. Gravely's attempt to connect dots is kind of futile because they're not connectable. So, and so I don't think I have no idea what kind of remedial measures could possibly be talking about, but this is an emotionally charged situation for everybody in the family on both sides, and especially for Mr. Anderson. And his daughter is up there testifying and obviously having an emotional time with it. I think that's uncontested. So we don't really know, what she heard or what he meant, or if he was talking to himself or anything. So I think that the court's admonition from before is more than sufficient, and we can move on. That's our.
The starting point is I don't know the truth of it. I know that it is a report from the clerk that what she perceived, and I did not see anything occur. Before I would take any remedial action, I would have to know the true facts. Under our law, I can, if I looked at it as a contempt of the court, I can punish only for contempts committed in my presence. There was a more expansive definition formerly, but the law was changed about, 30 or 40 years ago. And I think it's fairly clear now that the contempt has to actually have been witnessed by the judge. And just, I can't do that. And I mean, I didn't witness it, so it's going to have to be heard. And the three forms of contempt are punitive sanction. And since I didn't see the incident, I cannot impose that. Even if I could have a hearing and be convinced of the accuracy of what is reported. A remedial sanction, which would basically be telling him not to do it again. Even though I don't know if he did it or not. And, or refer it to you for a decision as to whether it's a